Please, your lordship. My lord, I would like to have the lordship's indulgence in item 47. Yesterday, this matter came up for motion,
Yes.
and then government has sought for time for getting instructions. And today it is to be listed for consideration of the interim. Now it is listed as admission matter, and going by the past precedents, up to the motion matters, it will go to the admission column in the part 1 list.
Yes.
So in which case, my two learned friends, Mr. Takamasa and TV Jamir, they are fully armed with their respective cases in one of the matters which is in the regular list. So that is likely to take some time. So I have taken their concern also to upgrade it to take the admission matter, that is item 47, up to the motion matters, lordship. Obliged.
May it please your lordship. Your lordship, I filed an affidavit in reply in the item number 25 this morning.
Okay.
My lord, my learned friend, the learned additional AG also will require some time, so we are making a joint mention for a matter to be listed after the vacation, my lord.
Okay. On the joint prayer of Mr. Joshua Seki, Learned Counsel for the Petitioners, and MS V. Shukri, Learned Additional Advocate General, Nagaland, for the state respondents, list the matter after 2 weeks.
My lord,
Okay. The affidavit in reply, stated to have been filed on by the petitioners today,
my lord.
be tagged with the case record.
Yes, your lordship, and interim may also be allowed to
The
continue.
interim order passed earlier shall continue till the next date of this.
My lord, obliged, your lordship.
May it please, my lord. Lordship, in item 22, I have received the affidavit in opposition filed by the state respondents. I may be kindly granted 2 weeks, lordship, to file my affidavit in reply.
Okay. Mr. Santianger, Learned Counsel for the petitioner, has prayed for and is granted 2 weeks time to file affidavit.
3 weeks, my lord.
3 weeks time to file affidavit in reply to the affidavit of opposition filed by the state respondents. This is the case accordingly after 3 weeks.
Much obliged, lordship.
Only date
Lord-
by the notice. Yes.
Lordship, in item 18, lordship,
18.
yes, I have instructions to withdraw the writ petition, lordship. So I may be allowed to withdraw the writ petition, lordship, by giving me the liberty to approach the appropriate forum, lordship.
Okay. Mr. Santianger, Learned Counsel for the petitioner, has submitted that he has instruction to withdraw the petition and to pursue the relief sought for in this petition before appropriate forum.
My lord, my lord.
So, Mr.
Appropriate forums or court, lordship.
Appropriate forum includes court also.
Lordship.
To be on the alert.
Mr.
See?
Ingravati, Learned Central Government Study Council.
If the withdrawal, lordship, I will not change my usual fee. That's why I would object to be on the lawyer side. Lawyer side.
As objection to the prayer made on behalf of the petition, closed up. In view of the above submission made by Mr. Santianger, the petition is dismissed on withdrawal, with the liberty as prayed for.
Much obliged, lordship.
Maps, lordship.
Yes.
Lordship, I beg to mention item 2042. Hearing list, lordship. The last item.
Yes.
Lordship, and if this matter can come up after 2 weeks, after the vacation, lordship. I'm for the petitioner.
On the prayer of Mr. Puseko Hotel, Learned Counsel for the petitioner, which prayer is made with the consent of the Learned State Council, the matter stands adjourned for 2 weeks.
Lordship, highly obliged.
Worship, I beg to mention item number 38, hearing item number 38.
Yes.
I'm for the respondent. Your lordship, this matter will be listed after Pucha vacation.
We have informed the other side
Yes,
with the consent of the Learned Council. With the consent of Mr. Asengla, Longkumar.
No, I'm in 38. I'm in
With the
38.
consent of the Learned Counsel for the petitioner, Mr. Im Chong. Learned State Council has made prayer for adjournment of the case for 2 weeks. The praise the Lord is the case of the 2 weeks.
Your Lordship, in item 38, the interim may be continued.
The interim, if any. Interim orders, if any, shall continue
I'm obliged.
in the meantime.
May I please, my lord? Lordship, I beg to mention item number 24. Lordship, in this matter, I'm here to file my counter affidavit. If 3 weeks' time may kindly be granted to me, my lord.
Anybody from the petitioner side?
Lordship, in fact, the petitioner and myself, we had
Okay, Mr. N. Angami. Learned State Council has prayed for and is granted, has submitted that he is yet to receive the necessary instructions to file counter affidavits and has thus prayed for 3 weeks time
3 weeks' time, my lord.
to obtain the necessary instructions and to file counter affidavits after 3 weeks. Release the case, praise the Lord, release the case after 3 weeks.
I'm deeply obliged.
May I please, Lordship. My lord, I humbly pray this criminal petition 37 of 24 is supposed to come up on the previous week, but it's not been listed. And since the lawyer from Delhi, and it seems they have reached here, Kohima. So I pray the matter be listed on Monday.
Monday,
Yes, my lord.
Monday. Monday.
Yes. my lord.
If time permits. If time permits.
My lord. Yes, my lord. My lord, I also beg to mention hearing item 40. I'm the counsel for the petitioner. On behalf of peace, when the matter may be fixed after 3 weeks, my lord.
Mr. So and so learned counsel appearing for Mr. P. Shuri and learned counsel for the petitioner has prayed for listing of the case after 3 weeks.
39.
Item 40.
My lord,
40.
here we have two cause lists.
Yeah.
In his cause list is item 39.
Mostly it is serial number 39, same party.
What is the WBC number?
WBC 310 of 2022.
It is 40 here.
Oh, in my costly, it is 39.
Okay. WBC 310 2022. Okay.
My lord, hello, brother.
Mr. M.G. Imchang and State Council for the respondents are is present.
May I please, your lordship. Lordship, I beg to mention item number 13, my lord. In the admission column, my lord.
Yes.
Lordship, here, I have received the affidavit filed by the state as well as the private respondent, my lord. So if I may be granted 3 weeks' time to file my reply, my lord.
Mass Luciani, the United Council Court of Petition has submitted that copies of the affidavit in opposition filed by the state respondents as well as by the private respondents. And not as well as and have been received recently and has prayed for how much?
3 weeks' time, my
3
lord.
weeks time to file affidavits in reply to those counter affidavits. The praise the Lord is the case of
Lordship, if the interim may continue till then, my lord. Obliged, my lord.
check and extend.
Lordship, I also beg to mention item number 41, my lord. Lordship, here, the pleadings are complete, my lord. So if this matter can come up for admission hearing after 3 weeks, my lord.
He is definitely complete hearing list on the prayer of Miss Lucinio, Learned Council Court of Petitioner, comma, which prayer is made with the consent.
My apologies, my lord.
Yeah.
I
Learned Council for the respondents.
Respondent 2 and 3.
Respondents, comma, is the case after 2 weeks.
Obliged, my lord.
For motion, item numbers 1 to 12.
May I please, your Lordship.
Yes.
Lordship, this is an application praying for deletion of the applicant's name shown as respondent number 5 in WBC 192 of 2023.
Yes, what is the ground?
Lordship, the applicant has tendered a resignation, but resignation letter dated 17/8/2024. And this
Yes.
My lord, since the matter is already in hearing stage, lordship, the pleadings are completed. We can take a short date and then we can dispose it off along with the IA together, lordship.
Lordship, the pleadings are not completed yet.
What about the IA? IA is for, she doesn't
Otherwise,
want-
lordship, we
she
don't
doesn't
have,
want to stay, he or she doesn't want to stay in the competition in the frame.
yes, lordship. Otherwise, we don't have,
With the outcome.
yes.
She
We,
is surrendering.
yes, we don't have any objection to that, lordship.
Battle is won for you against respondent of 5. There will be no battle against
Yes,
respondent of
lordship,
5.
lordship. Otherwise, we don't have any objection, lordship.
Since she is submitting in oath. Heard, Mr.
Nongosa on behalf of MS Nuksungtila.
And counsel appearing for Mr.
MS Nuksungtil.
MS Nuksungtila.
Lordship.
And counsel for the applicant. And Mr. Toshio Longkuma.
Yes, lordship.
Learned counsel for the opposite party. Number opposite parties as read petitioners. First of. The opposite parties as the read petitioners have preferred the accompanying relocation, WBC number. WBC number 192. WBC number 192.
Bless you.
The ceiling. Appointments. Of the respondent number 52. Respondent number 8. Arid therein. As assistant professors in psychology and philosophy without advertisement in which college? College?
Yes, Lordship. Dimapur Government College.
In Dimapur Government College.
Department of Psychology.
In Dimapur Government College without advertisement. Full stop. In the same petition, comma, the applicant herein, comma, Srimoti Puli ICC,
Lordship.
who was appointed as an assistant professor psychology in Dimapur Government College, has been impleaded as party respondent number 5.
5, Lordship.
Full stop. Para. The instant interlocutory application has been filed by the applicant, Puli, Srimoti Puli ICC, who has been impleaded as party respondent of 5 in the accompanying writ petition WBC number so and so. Seeking deletion of her name as party respondent number 5 in WBC number 192, 2023. Full stop. Para. It has been averred that the applicant, that is the party respondent number 5 in WBC number so and so, has decided to pursue a new career path after consideration and self-reflection. Full stop. In order to pursue a new career, the applicant, yes, respondent of 5 has already tendered formal resignation from the post of assistant professor, Department of Psychology, on fixed pay at Dimapur Government College, Nagaland, with effect from 17/8/2024. Full stop. it has been further averred that on receipt of the said resignation letter dated 19/8/2024, the principal, Dimapur Government College, Dimapur, has forwarded the same to the Director, Higher Education, Nagaland, Kohima, on 20/08/2024 for acceptance. Full stop. Mr. So-and-so learned counsel for the appearing for the applicant has submitted that the petition, sorry, applicant is not interested in the outcome of the accompanying writ petition. And as such, her name as party respondent number 5 from the area of respondents in WPC number so and so be deleted. Where in view of the above submission, averments made in the interlocutory application and the submission made by the learned counsel appearing for the applicant as party respondent number 5 in WPC number so and so, the prayer is allowed. Accordingly, it is ordered that the name of the applicant as party respondent number 5 in WPC number so and so is to be deleted and is to be deleted. Is to be deleted, and the registry is to make necessary corrections accordingly.
Pleasure, pleasure.
For motion item numbers 43 and 44.
Given number 43, 44.
May I please, Your Lordship?
Yes.
Your Lordship, this IA is for impleadment of the new incumbent Sri Anu Kinchi IAS, Commissioner and Secretary Health and Family Welfare as respondent number 4.
Okay. Hard. MS
Asnla.
learned counsel for the applicant. Full stop. It's an interlocutory application under Order 1, Rule 10, within bracket 2 of the Code of Criminal Procedure 1973 is preferred, seeking impleadment of the following person, or seeking impleadment of quote unquote Sri Anu Kinchi, IAS, Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department, Nagaland, Kohima, as party respondent number 4 in the accompanying contempt petition, COP, within bracket C number 17 of 2014. Para. The accompanying contempt petition, COP C17/2014, has been preferred by the applicant as contempt petitioner, applicants as contempt petitioners, alleging non-compliance of the direction made in a judgment and order dated 22/11/2023, passed in writ appeal number 14 of 2019. Full stop. Where it has been averred that during the pendency of the COP number so and so, the respondent number 1 Daring, retired from service from the post of Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department in August 2024. And Sri Anup Kinchi, IS, is presently serving as a Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department, Nagaland. Full stop. With the aforesaid projection, it has been averred that the presence of Sri Anup Kinchi, IS, Commissioner and Secretary to Nagaland, to the Government of Nagaland Health and Family Welfare Department is necessary for adjudication of the accompanying contempt petition number so and so. First off, having regard to the aforesaid projections, and the averments made in this interlocutory application, this court is of the considered view that the presence of so and so Commissioner and Secretary to the Government of Nagaland Health and Family Welfare Department, Nagaland, Kohima, appears to be a necessary party for adjudication of the accompanying contempt petition, contempt so and so. It is accordingly, this instance interlocutory application stands allowed. First of the registry, you have to file amended cost title for this. The learned counsel for the applicants petitioners, contempt petitions, is to file amended cost title in the accompanying contempt petition. So we need 2 working days from today. And on submission of such amended cost title, the registry to make necessary correction in the cost title and thereafter release the contempt petition accordingly after a week.
Mr. Chair.
For motion, item number 45.
May it please the Lordship. Lordship, the petitioner herein is seeking for regularization of his service. As he has already completed 34 years in service and is receiving scale pay. And he has fulfilled the conditions of the OM dated 17/03/2015.
As per the OM, this petition may be disposed, Lordship.
Yesterday we have disposal.
Yes, Lordship.
We can dispose of in similar lines.
Lordship.
Heart, Mr.
Yes, of him, my lord.
Yes, okay. People who vote us. Learned counsel for the petition and MSS Chang, learned government advocate for all the respondents. Anything? No? Para 2 लिख लो, para 2. In view of the nature of issue involved and as agreed to by the learned counsel for the parties, this petition is taken up for consideration at the motion stage itself. Full stop. Para, the projected case of the petition is that initially by an office order dated 17/9/1990, Annexer 1. the petitioner came to be appointed as a ward charge labor on fixed pay with effect from 17/9 to 1990. And pursuant to the said office order, the petitioner joined his service as a ward charge labor in the establishment of the executive engineer, public health engineering department, PhD, Tuensang, district Tuensang, Nagaland, while the petitioner was continuing his service as ward charge labor on fixed pay, he was upgraded to ward charge Khalasi by providing him scale of pay by an office order dated 25/2/2021, Annex 2. Passed by the Chief Engineer, PhD, Sanitation, and WSSO, Nagaland, Postal, Para. Having regard to the situation faced by the work charge and casual employees, the Personnel and Administrative Reforms Department, Government of Nagaland, has framed a scheme for regularization and absorption of work charged and casual employees in the year 2015, and the said scheme has been notified by an office memorandum dated 17/3/2015, Annex 3. So, as per the said office memorandum dated 17/3/2015, all existing work charges, so and so, Then, para 5. It is the further case of the petitioner that finding the petitioner eligible. Your case was forwarded.
I submitted a representation, my lord.
Okay. It is the further case of the petitioner that on being eligible, he submitted a representation before the Chief Engineer, Public, PhD, Nagaland, on 24/7/2024. Representation Annex 4. And the receipt of the same representation was duly acknowledged by the Office of the Chief Engineer, PhD, Nagaland, on 24/7/2024 itself. Full stop. Para 6. Para 7, MS Chang. That's 7, para 8. Para 9, para 8. As expeditiously as possible, preferably on or before 31/1/2025.
Obliged, my lord.
For motion, item number 46.
Please, your lordship. Your lordship here. The petitioner is challenging the order dated 12/8/2024.
Page
46, my lord. 12/8/2024. By this order, the state respondents appointed the private respondent number 5.
The petitioner herein is challenging the said order on the grounds that it is not in consonance with the office memorandum dated 16/08/2018, and also in violation of the judgment of this honorable court dated 27/03/2024, passed by the division bench of this honorable court in writ appeal 11 of 23, my lord.
What was the repetition? Repetition?
Writ appeal 11 of 23.
This repetition was preferred by whom? The page 23?
Firstly, the writ petition was filed by the husband of the present petitioner, numbered as WPC 11 of 23. And thereafter, this honorable court was pleased to allow the writ petition. Thereafter, being aggrieved by the order of the honorable court, the private respondent number 5 preferred an appeal, numbered as WA 11 of 23. And thereafter, by an order dated
Come to page 23.
23, my lord.
This is asking for recharge.
The petitioner was, in that case, was the husband of the present writ petitioner.
Petitioner to appoint a petitioner to a post of any male attendant. This is recharge.
Yes, my lord.
So what was the direction in the writ petition?
In the writ petition, the state respondents were directed to appoint the petitioner.
Appoint a petitioner.
Yes, the petitioner. In that WPC 77 of 23.
Consider take immediate necessary steps for his appointment being covered by office memorandum of services by regulation of service. Chair, you were respondent number 5.
No, my lord. I am
In the
the,
writ petition, in the writ petition.
in the writ petition, I am the petitioner. I am the petitioner.
No, please.
In the,
In the writ petition.
Yes.
23.
yes, my lord.
You were respondent number 5.
No, my lord. I am the petitioner. I am the petitioner.
Okay, you are the
I am the petitioner. My husband was the petitioner. Not me. My husband was the petitioner.
husband was the petitioner.
Yes, my lord. In WPC 77 of 23, my husband was the petitioner.
And direction was to appoint him.
Yes, my lord. And
And the
thereafter,
respondent number 5
being aggrieved,
preferred an appeal.
yes, my lord.
That what was the
Then my lord was pleased to pass the judgment dated 27/03/2024. And thereafter, the direction of this honorable court was to direct the state respondents to,
respondent number 5 was earlier appointed.
yes, my lord.
So her appointment was set aside.
Yes, my lord.
And it was observed by the division bench that the cancellation of appointment of the respondent number 5
Yes, my lord.
by the learned single judge shall not operate as a bar for him to stake claim for appointment on the basis of land ownership
Yes, my lord.
vis-a-vis the petitioner respondent number 1 and any other applicants taking claim for appointment to the said vacancy on the basis of land ownership.
Yes, my lord.
Neither any finding has been reached in the petition observing that the writ appellant, the respondent 5 is not eligible to apply grade 4. Okay, then thereafter,
Advertisement was published by the state respondents.
yes.
An interview was called up. There, the wife of the petitioner, the present petitioner appeared for interview, and she was issued NP card. The respondent number 5 also appeared for interview. And thereafter, the respondent number 5 was selected. But my lord, this honorable court also made an observation at page number 39. Page number 39. This honorable court also made an observation. The deputy bench of this honorable court. May I read, my lord? Having heard the learned counsels for the parties and after considering the matter in its entirety, we are of the considered view that the matter of filling up the post in grade 4 at veterinary dispensary Jakama shall be strictly in terms of the office memorandum dated 16/08/2018 by the competent authorities in the state government, my lord. Yes. So, my lord, I am challenging the
What is the
appointment.
office memorandum?
The office memorandum is at page number 41, my lord. May I read, my lord? The relevant portion is at para 3, subclause B. May I read, my lord?
Yes.
It is also clarified that it is not the policy of the government to provide employment or other facilities to the landowner in perpetuity. And now here, the family of the respondent number 5 has already availed the benefit to be appointed on the basis of land ownership, my lord.
Wherefrom it is evident?
My lord, his uncle, Juan Teposiotase, was serving. And
Is it a
his-
recorded fact? Is it a recorded fact somewhere
No, my lord.
Hmm?
No, my lord.
in this writ petition only?
Yes, my lord.
In this writ petition only?
In the previous writ petition also,
yes.
I allege.
Is it recorded in the judgment anywhere? Either by the single judge or by the division bench?
Yes, my lord.
Where?
My lord, may kindly turn to page 33, my lord. Page starting from
Please.
32, my lord. Last para, my lord. This court also finds that if the appointment of the respondent number 5 was made by virtue of him being the descendant of the same landowner, Sri Kodon, it will not be in consonance with the office memorandum dated 16/08/2018. And therefore, the appointment order dated 31/03/2023 is liable to be set aside.
Page 30.
32, last part, last sentence, my lord.
But come to page 39.
Yes, my lord.
Neither any finding has been reached in the writ petition. Observing that the writ appellant, thus respondent number 5, is not eligible to apply for the post of grade 4 in question on the ground of land ownership or the state government. And the petitioner, thus respondent number 2, have claimed so. So we have to reach a finding here. In this case,
Yes, my lord.
that division bench has held that, see, read again, neither
Neither any findings
has been reached in the writ petition. We have to issue notice.
Yes, ma'am.
You have to establish that Khujon is the descendant
Yes,
of
yes, yes, my
the
lord. I will do
respondent
that.
of 5.
Yes.
Heard Mr. A. Sophie, Learned Counsel for the petitioner. and Mr. Im Chong, learned senior government advocate
Lordship,
for the respondent number
1 to 4.
1 to 4. Full stop. In this petition, the petitioner has essayed an order dated 12/8/2024, Annex G, whereby the respondent of 5 has been appointed to the post of animal attendant at VD Jakhama under the establishment of the Chief Veterinary Officer, Kohima, in the Department of Animal Husbandry and Veterinary Services, Nagaland, Kohima. Full stop. The appointment of the respondent of 5 appears is made pursuant to an advertisement. Where is the advertisement?
May I interrupt your lordship? May I interrupt on behalf of the state?
Which number
Lordship,
42?
Lordship, we are just following the order and direction given by the division bench of this honorable high. The lordship, please appreciate the operating direction given by the division bench of this court. Lordship, you will find, if you, page 39, if you start from the last line, 7, this is the operating directive given to us by the division bench. Here it, your lordship. From the last line, it comes to number 7, line 7. The state respondents, while proceeding to fill up the vacancy of the grade 4, both in the veterinary dispensary, Jakhama, shall invite applications from eligible as applicants claiming appointment on land ownership basis by virtue of the agreement dated 8/12/1975 with Wet Public City, and thereafter to proceed to complete the entire exercise as expeditiously as possible, preferably within 4 months from today. It is needless to say that the cases of the applicant are to be considered on the basis of actuating supporting documents. Accordingly, the appeal was dismissed with this operative direction, your lordship. So now we have advertised in compliance with the order. Lordship, the advertisement you will find in page 43. 43 is the advertisement. And your lordship, the appointment of the private respondent number 5, you'll find your lordship, and page 46. We have constituted a lordship state requirement form.
No, for what purpose you were submitting? I'm not saying anything.
Lordship, I'm just saying,
Because you come to page 39,
yes, lordship.
we have recorded neither any finding has been reached in the writ petition.
Lordship.
Observing that the writ appellant respondent of 5 is not eligible to apply. That means the present respondent of 5 also. For the post of so and so in question on the ground of land ownership, nor the state government or the petitioner respondent number 1 have claimed so. So
Yes,
he's
lordship.
still saying that this respondent of 5 is a descendant of Khujon.
Yes, my lord.
And as per the office memorandum,
Lordship.
there cannot be further appointment in perpetuity
Lordship.
from the same descendant.
Lordship.
Now he has to prove, establish. We are issuing notice.
Yes,
That only,
lordship.
nothing more. Okay. Pursuant to a selection process initiated by an advertisement dated by an advertisement within bracket annexer. This is not an annexer. What?
Annexure D.
Advertisement annexer. I'm sorry, advertisement. Annexer 5 published on 17/7/2024. Full stop. Mr. So-and-so learned counsel for the petitioner has submitted that as per the office memorandum,
16/8/2019.
page
Page number 41, my lord.
16/8/2018. The policy of the government has provided that the employment from the landowner's family cannot be in perpetuity. Full stop. It is his contention that one Kujon, who is a descendant of the respondent of 5, got appointment earlier.
My lord.
Huh?
Kuzon is the landowner,
Huh?
is the landowner.
Huh.
And thereafter, one Tepuseo Tase, he only the adult on behalf, in the name of Kuzon.
I get confused with all these landowners.
Lordship, there are 6 landowners here. That means 6 clans are connected. So-
No, you are
No,
seeking
my lord, that-
cancellation of the appointment of the respondent of 5
Yes, my lord.
on the basis of landownership.
Yes.
On what ground?
On the grounds that his family has already availed the benefit.
Okay.
One Tepuseo Tase was appointed.
Huh.
And on his
Okay.
retirement, the vacancy was
Okay.
created.
Okay. It is the contention of Mr. So-and-so learned counsel for the petitioner that the respondent of 5 cannot be made eligible to appoint to be appointed on land ownership basis for the reason that one of the descendants of respondent number 5 had already got appointed on land ownership basis. And as such, the appointment of the respondent of 5 by the impugned order dated 12/8/2024 is clearly against the policy of the state government. Full stop. The matter would require further consideration. Issue notice returnable in 4 weeks as Mr. Imchong, learned senior government advocate, has appeared and accepted notice on behalf of the respondent number 1 to 4, the issuance of formal notice to the said respondents stand dispensed with extra copies within 2 working days. The petitioner shall take steps for service of notice upon the respondent number 5 by registered post with AD within 2 working days. This is the case after 4 weeks.
Obliged, my lord.
For motion, item number 47.
Please, your lordship. Yesterday, I was granted a day's time to obtain instruction as to how the state level executive committee had reviewed the scheme for relocation of the project from Mongsemti to Chapa. Accordingly, your lordship, I have received the instructions from the concerned department. Therefore, if I may be allowed to furnish the same to your lordship. Your lordship got it. May I read your lordship? May I read your lordship?
Yes.
To such and such, subject such and such, sir, I'm directed to refer to the subject cited above and to submit herewith the following documents for your information and further necessary action regarding relocation of the project, construction of multipurpose building from NH Mongsemti to Chakwa village under Mogokchung district, sanctioned by the Ministry of Tribal Affairs under proviso to Article 275 Clause 1 of the Constitution during 2023-24. White letter dated such and such, dated 6/9/2023, enclosed Annexure 1. Number 1, that the project for construction of multipurpose hall at Mongsemti, Mogokchung district, which was sanctioned by the Ministry of Tribal Affairs during 2021-22 under proviso to Article 275 Clause 1 of the Constitution dated 30th/9/2021, enclosed as Annexure 2. This project and construction of multipurpose at NH Mongsemti are in close proximity within the same plot.
Which one,
The-
which one, which one?
Annexure
Annex
2, page 9, Your Worship,
page 9,
at serial 26.
page 9.
Serial number 26. Your
Yes,
Worship.
26.
May I read, Your Worship?
Uh-huh.
Construction of multipurpose hall at Mongsemti compound,
Hmm.
Mogokchung, 50 lakhs,
Hmm.
which was sanctioned, and accordingly, the said multipurpose building was constructed and completion certificate also issued by the concerned administrative officer as well as by the village council also, which is at Annexure 3, Your Lordship. The completion certificate dated 5/7/2024, along with geotech photographs of multipurpose.
From
hall.
where you are reading?
I'm reading from the covering letter, Your Worship.
Covering letter.
Yes, my lord. That is.
Uh-huh. Okay. Two. Okay.
Yes, my lord. During 2021-2022, enclosed as Annexure 3.
Lordship, for the ministry, I have received a copy just today. So I mean.
Let me let me hear him. You are not there. We asked for your presence yesterday. We recorded your absence yesterday. Yes.
Your Lordship, at serial 3, Chief Minister's TO letter dated 12 October 2023, and CM's office letter number such and such dated 20th January 2024 as Annexure 4 and 5, which is at running page 16-17. That is.
1 minute.
Page 16 and 17.
Now, what is 15? This photograph?
Geo, it is about the completion of the multi-purpose.
There is a house,
Yes, my lord.
completed house.
Completed with a sanction amount of 50 lakhs under the same village. Mongsemti.
Now, let us see
Page
the,
15 is
yes,
the-
let us, page 15 is the photograph.
Yes, my lord. Completion certificate.
Okay,
Of
let
the
us see,
construction of this
let us
multipurpose.
see, page 13.
This is about the completion certificate issued by the
5th July
administrative officer.
2024.
It is at
Then
Annexure
it is
3.
certified that by Ministry of Tribal Affairs. 8/7/2024. Page 14 is 8/7.
This is from Mongsemti Village Council
And this is from, page 13 is
It's
extra assistant commissioner.
as extra assistant commissioner.
And
of
page
the
15 is the
General-
photograph.
Yes, ma'am. Where the same multi-purpose hall was constructed
Huh.
at Mongsemti.
Now.
Thereafter, your lordship. How the relocation has to take place.
Hmm.
page 16, Your Lordship,
PS6.
running page 16, annexure 4.
Yes,
May I read, Your Lordship?
yes.
Your letter such and such. Dear Shri Arjun Munta Ji, I write this letter with regard to change featuring at serial number 16 on the infrastructure in the priority list of project proposals under Article 275 clause 1.
Which one serial number 16?
16, my 16 annexure 4, Your Worship, page 16
Page
of my letters.
No, I read this letter with regard to change featuring at serial number 16.
Yes, 16 is about,
Under the infrastructure in the priority list of project proposals.
yes, ma'am.
Ah.
Shall I continue, my lord?
Oh, this 16 is which one? From the photographs, it appears that there is there exists as on date
Yes.
a community
Multi-purpose building
community hall.
at Monsayamki.
Yes.
So
Uh,
how this relocation has to take place? If I may be
So
allowed to read-
that is about 50 lakhs.
Yes, ma'am. In the same location, in the same village.
No, because see, just to understand. Annexure 1, page 1. You are appearing for?
I have instructions to appear for the Chapta Village Council, Lordship. However, I have not been included.
Okay. Come to page 1. Dates are important. 6/9/2023, right?
Yes, ma'am.
Their
Another-
proposal at serial number 8,
Serial number 8 is
construction of multi-purpose building.
at Monsayamti.
Yes,
Same village.
1 crore, 1 crore,
Yes, ma'am.
1 crore.
Yes, ma'am.
Then come to page 6.
Page 6,
That is dated
serial number 26.
39. So this is amount released.
Yes, ma'am. Yes.
Now here, serial
Here,
number
26.
26.
Yes, ma'am. Construction of multipurpose. hall.
There it has become 50 lakh.
No, my lord. This is for the first sanction order
Amount sought for.
in 2021 and 22.
Ah,
And the latest is 2023 and 24.
1 minute.
The same multipurpose building is,
Then after that,
Lordship, if I may interrupt and assist. Lordship. There already is a multipurpose.
Hall.
Lordship. The building that is already completed, Lordship. In the petitioner's village, Lordship. Now, another multipurpose hall, they are seeking to be established within their village, Lordship. That is the issue, Lordship.
I know, let me come with the documentary thing. Verbal is okay.
Yes, Lordship.
page 1, annexure 1 is the latest sanction order during 2023 and 24. Where another multipurpose building at Monsayamti is to be constructed, amounting to one crore.
Page,
Page 2, serial 8.
page number
2,
page 2.
page 2, serial number 8, my lord. This is the latest sanction order, which the petitioner is claiming.
So according to you, there is a multi-purpose
Building.
hall,
Already.
hall, Bonseng Semniti compound
Yes,
constructed at the cost of rupees 50 lakh
yes,
already
yes,
there.
ma'am.
Yes,
Chief. The reasons given by the Chief Minister in his letter. is
now
to-
plus, first clarify the thing, whether this phase 14, 13, 14, 15 are correct or not. This is correct or not.
I have to get instructions, so far as that project is
If this
concerned.
is in existence in July 2024, we'll see about the public interest.
Yes,
We are not going to do anything
yes,
private interest.
yes,
We are on clearly on the aspect of this is an infrastructure project.
yes,
If this is existing in your village, constructed with a fund of rupees 50 lakh from the Ministry of Tribal Affairs.
yes.
And if there is no multipurpose building in Chapra or Chakra or whatever, for the community at large,
Lordship.
we are not, community interest will prevail over private interest.
Sir, I fully agree, Lordship.
Now tell me this is in existence or simple.
Let them file affidavit, a detailed affidavit. I will also reply to that. Firstly,
Meantime, Lordship.
Secondly, Lordship.
Included as a party, Lordship. The Chappa village council may also be included as a party.
We'll see to that, we'll see to that, we'll see to that.
let them file a detailed affidavit. I will keep a fitting reply.
File it by
Yes, ma'am.
Monday.
Yes, ma'am. 3 weeks time may be granted. Lord. 3 weeks time.
No, we are on consider, if this is on your statement, we'll record that.
Yes, ma'am. Secondly, Lordship.
So far as interim order is concerned.
Secondly, Lordship, another aspect. State level executive committee is formed under the chairmanship of the chief secretary. They have examined all the pros and cons and a selection was taken. If that is the ground, they could have not selected my
Mr. Jami, guidelines are
case
not
also.
enforceable in a court of law. These are guidelines. Otherwise, this is not law. Question is here that we are about the community interest. Infrastructure project is not to be stalled just at the filing of a writ petition.
Yes.
But since you have asked that it has been shifted, then we considered the entire aspect, and that is why I asked why it is shifted.
Yes.
But if the cause is that there is already a multi-purpose community hall in existence,
Yes.
then we have to see the things in a broader perspective. If there is a community hall in existence, utilizing the fund of Ministry of Tribal Affairs to the extent of rupees 50 lakh, and there is no community hall in existence in Chapra, Chakpa, then we have to see what order is to be passed.
Yes.
We can issue only notice at this stage. And we can consider your interim prayer. Since it is a statement coming from Secretary to the Government of Nagaland in a set of instructions.
Necessary party is Chakpa village. If that is the case, from the day one, they should not have even proposed and trouble me also. Your Lordship, no,
That is true. That is true.
why they have trouble me
That
unnecessarily?
is, I don't know that.
And
I
they
don't
have
know, but
followed
we have
all
to
the
see the,
procedures.
we have to see the community
procedure.
interest. So far as infrastructure project is concerned, we have to see that. That is why Section 80 has been incorporated in a specific relief act. No injunction
Your
in
Lordship,
case of infrastructure project.
if this kind of practices are allowed, entertained, for 2023-24,
That
as
is,
many as 21 projects have been approved. Out of that, tomorrow if a VIP write a letter for change of location from one place to another, the department is
this court was also of
Setting
that
to
understanding that why it has been
implement the
shifted.
government projects or just to prepare the
But
projects report
after
and
looking at,
change from time to time.
after
To lay
looking,
down a bit
but
precedent,
after looking at page 15,
Lordship.
photograph, view is changed to a certain extent. If this is true, then a community hall, multi-purpose community hall is already in existence. And Mong Sen Imti village has already received 50 lakhs grant from the Ministry of Tribal Affairs.
That is, location is also different. Mostly NH to Mongsimti.
Nagaland villages are not so big. Villages are not so big.
And it's not that they were ignorant about the existence. They have granted the sanction for this project. By granting another project sanction, what is wrong? What guidelines have been violated? And which guideline says that there can be no hall in one place only? For example, I would like to cite an example, Lordship. NPC is issuing advertisement from time to time. Many thousands of candidates will apply. And suppose from one particular village, if 10 candidates are selected in that examination, can anybody say that no, 10 persons have been selected from only from one particular village? That should not be appointed, that should not be accepted.
Now,
Should that be the basis?
now tell me, if there is a multi-purpose building is in existence already in that
I
village,
don't know that.
this is a statement coming from a secretary.
Let them file an affidavit.
They'll file. We are on the consideration of interim period. We are deciding it. That is all.
But the
We'll issue notice.
decision, the grievance of the petitioner is only to the extent of changing of the location. After approval, what was the justification to change it? Because at the time of examination, all these factors have been taken into consideration. If they have constructed, they should have come with a plea that, oh, there is already a building in that location. So we cannot approve it. They should not have approved.
There is a case for damage,
Have
Mr.
factored it.
There is a case for damage.
Your lordship, no damage has been caused and no irreparable.
No
loss
personal damage.
to the petitioner. And this is the state policy making decision.
Heard Mr. C.T. Jamir. Learned Senior Counsel assisted by Mr. Aliba Ojukum.
I am Jen today.
I am
Counsel has been changed.
Learned Counsel for the petitioner and Mr. L.T. Sanctum, Learned Additional Advocate General Nagaland for the respondent number 2 and 3. Also heard Mr. Yengarbati, Learned Central Government Counsel for the respondent number 1. Full stop. The submissions. On behalf of the petitioner have been advanced yesterday by Mr. C.T. Jamir, Mr. Jamir, Learned Senior Counsel, and the same have been recorded in the order dated 23/9/2024. Full stop. Having regard to the submissions made on behalf of the petitioner, Mr. Sanctum, Learned Additional Advocate General, Nagaland, sought time till today in order to obtain relevant materials as regards change of location of the multipurpose building from Mong Seng Imti village to Sakpa village within the district of Mokokchang. Full stop. Yesterday's para 2, para 3, para 4, para 5, para 6, para 7. But the matter would require further consideration. Issue notice returnable on 3 weeks. Fixed date. 27, 1810. 18/10/2020. As Mr. Swains has appeared, Yangarvati CGC appeared and accepted notice on behalf of the respondent number 1 and Mr. Sanktam, Lanet Additional Advocate General, for 2 and 3. Issuance of formal notice to the said respondents as dispensed with.
I'm not aware of what order was passed yesterday. So if the order to be.
Yesterday, his submissions were recorded. His submissions were recorded and facts stated in the writ petition were recorded. Nothing more. Extra copy within 2 working days. I cannot direct anybody to implead somebody at this stage. At this stage, you can get yourself impleaded. There is no bar subject to contest, right? So I am not giving you audience at this stage. No, I have to record. Also heard the learned counsel for the parties on the interim prayer. The petitioner in this writ petition has prayed for an interim order to the extent that the impugned order, the letter dated 8/4/2024. Which letter? That means 8/2/2024, Annexer I. And the decision taken in the meeting of the State Level Executive Committee, SLEC, held on 22/03/2024 are to be stated. By the letter dated 8/2/2024 of the Ministry of Tribal Affairs, GOI, the Ministry of Tribal Affairs, GOI, has acceded to the request made by the Tribal Affairs Department, Government of Nagaland, to change the project location of construction of multipurpose building from NH Mong Seng Imti village to Chakpa village within the district of Mokokchang. By the decision taken in the meeting dated 22/03/2024, the SLEC recommended the construction of multipurpose building approved by the Project Approval Committee, Ministry of Tribal Affairs, GOI, during the financial year 2023-2024 under Article 275 within bracket 1 of the Constitution of India, by relocating the project from Monseng MT village to Chakpa village under the same constituency and within the same district, subject to compliance of the terms and conditions of the letter dated, incorporated in the letter dated 8/2/2024 of the Ministry of Tribal Affairs, GOI. Full stop. Today, Mr. Sanktam, Learned Additional Advocate General, Nagaland, has placed a set of instruction communicated to him, a white letter bearing number so and so dated 24/9/2024, under the hand of the Joint Secretary to the Government of Nagaland, Tribal Affairs Department, Nagaland. Full stop. From the documents it has appeared privacy that earlier, by later dated 39/2000, later number, page 6, 39/2021, the Ministry of Tribal Affairs, Government of India, GOI, released an amount of rupees, a sum of rupees 15,95,69,000 to the Government of Nagaland towards creation of capital assets for grants under Article 275(1) of the Constitution of India for the year 2021-2022 to carry out the activities mentioned herein. Full stop. One of the activities for which an amount of rupees 50 lakh has been released is construction of a multipurpose hall at Mong Sen EMT compound. Full stop. The letter further mentions that the amount approved by the Project Approval Committee for the year 2021-2022 for the same is 50 lakhs. Full stop. From the completion certificate issued by the Extra Assistant Commissioner, Suchu, page 13, Nagaland, it appears privacy that construction of a multipurpose hall at Mongseng EMT compound undertaken by the Directorate of Tribal Affairs, Nagaland, Kohima, has been completed, and in that connection, a photograph of the completed multi-purpose hall at Monsing Empty Village, Nagaland has been annexed at page number 15 of the set of papers. Poster. A construction, a community, multi-purpose community building is for the benefit of the community at large. And the basic object and purpose of grant under Article 275(1) of the Constitution of India is for creation of capital assets. Full stop. It is true that by the proposal, it is true that a proposal was approved by the Project Approval Committee, PAC, in the Ministry of Tribal Affairs, GOI, for construction of a multipurpose building at NH2 Monseng EMT at a projected cost at a cost of rupees 1 crore was approved. And the same was to be constructed in a land belonging to the petitioner. But having regard to the projection made on behalf of the state respondents, that a multipurpose community hall has already been completed in Monsing Empty Village in July 2024, this court on the basis of such materials placed before this court is not persuaded to pass any interim order at this stage.
For admission, item number 14.
About this, about this. Where is this? It was this, where is my list? It is there. This is bottom, no? Yes.
Well, not before I go to the Indian orders. The case has a long checkered history, so kindly allow me to take around 10 minutes so that I highlight to your lordship the facts of.
This has come for what? Contempt petition?
Yes, lordship, it's a contempt petition, but the second round of litigation before this honorable court on the prison contempt.
Hmm.
My lord, in my more than 35 years of practice, this is the first time I have come across to my affidavit in reply, and reply affidavit also has been filed. Now, my lord, lordship, kindly to ensure that, since it has got a long checkered history, kindly allow me about 5-6 minutes so that I narrate the facts of the case so that your lordship can grasp the issue in a.
My grasp of content jurisdiction is very limited.
I understand. That is why, my lord, because the usual understanding is whether the judgment is complied or not.
Yes.
That
is a simple
That
understanding.
is a simple understanding, but my lord, lordship, kindly keep.
I do not know anything further to that.
Yes. So there, my lord, because my lord, after the division bench passed the judgment, lordship, my lord, in view of section 6(2) of the Contempt Act of 1977, covered High Court rules. Though, my lord, the judgment is of division bench in the civil nature, contempt is filed before the single bench under 6(2) rules, section 6(2) of the High Court rules of 1977. Now, lordship, why, my lord? I'm praying for your.
Because otherwise, in the principle, if the disobedience is in respect of a judgment of a division bench, then it will be before the division bench.
My lord, if the lordship again
But if single judge has passed an order, my understanding, just telling, and the division bench has affirmed, then it will be single bench.
Yes, single judge should pass an order.
Yes.
My lord, so kindly allow me to narrate those facts so that those issues has to be clarified. That's why, my lord, I'm trained for lordship, trained for short. My lord, the petitioners before your lordship. My lord, I'll take about because big affidavits.
Who is a petitioner?
My lord, the petitioner, the village guard associations of Nagaland.
So many pleadings.
Yes, that's why, my lord, to overcome all these pleadings. Kindly allow me about 10 minutes.
Sure.
Just the village guard association of Nagaland.
I am trying to locate your petition.
Yes.
Original petition.
Yes, the village guard associations of.
Okay,
Nagaland.
village guard.
Yes. My lord, the issue is the village guards. My lord, kindly allow me to give a brief background of the village guards. My lord, the village guards, when the insurgency was at its height in the state of Nagaland, my lord, in the interest of nation, my lord, the village guards were established in the year 1957.
So my apology for interruption. In case if your lordship has reservation, what your lordship has said that any order passed by the single judge, if that is upheld by the division bench, then single judge can take up the contempt matter. But this is a case where the division bench has partially set aside the judgment passed by the single judge. So that is the, after hearing, in case if your lordship.
This is my understanding.
I'll go to the rules. I'll go to the lordship.
I have said this while looking at the practice or convention. I have not read any book.
My lord, I will satisfy you, lordship, because the learned single judge, the division bench, had only modified the judgment of the single bench. To that extent, I satisfy you, lordship. Now, my lord, since my learned friends have addressed the issue, my lord, the Gauhati High Court rules 1977, 6.1 says, when it is a criminal case, before division bench. 6.2 says, my lord, when it is in the civil side, the decision of a division bench before a single bench. That is what rule 6.2 of, I'll produce the rules. I thought that I'll satisfy your lordship on that point. But prior to that, lordship, can you allow me a brief background of the case so that your lordship appreciate it, so that all this long affidavit can be made shortcut. My lord, the village cards were established in the year 1957. Then, my lord, they were functioning in aid of civil police in the state of Nagaland. And initially, you were given because they are village volunteer forces to protect the villages during two situations you were established. Then, my lord, after statehood, in the advanced districts of Mugukchung, Kohima, Zanupoto, my lord, the village guard volunteers were you were compartized and you were allowed to join Nagaland armed groups. But it was a policy decision of the government to allow in the backward district. Then it was only Toensang and Mo and Kohima. They were allowed to continue. Now presently, in the 6 districts of Nagaland, the home guards, the village guards are there. Presently, mother total strength is 9,583 personnel. One of they are given arms training. All of them are given. This will be unique to Nagaland. One of they are given rifles. You are given arms trainings, and thereafter, mother they stay in their homes. And as and when the duty calls, we perform various duties. Mother duties in function. I'll produce the documents to satisfy your lordship. Now, my lord, initially, when we approached this federal court in the year 2017 before the single bench, we were paid an honorarium of rupees 1,500 rupees per month. Then we were paid, my lord, rupees 500 as clothing allowance, yearly 500 rupees because we wear uniforms like any other forces. And we were given 25 rupees as footing allowance when we go outside the village for duties. 25 is not even sufficient to buy anything. Anyway, that was the situation. So, my lord, we submitted a representation before the competent authority. And the competent authority was pleased to forward our case to the government of India. Because, my lord, whatever honorarium is paid to us, it is recovered from the MHA as under security expenses. We are employees of the state government, state of Nagaland. The village council took the verification, and then we are appointed by the respective commissioners. We are employees of the government, state of Nagaland. But then recovery of the expenses, that is the issue. So, my lord, lordship.
Okay. We'll resume after 5 minutes.
Yes.
Yes. So, my lord, we submitted a representation that we are paid only 1,500 honorarium whereas we are performing law and order duty like any other security uniform service. And we are trained also. So we submitted a representation to consider for enhancement of our honorarium. The representation was submitted, my lord, on 28/9/2015. Then, my lord, the government of Nagaland, Ministry of Home Department, had forwarded our case on 35/2016. That with MHA, that our honorarium should be revised to 5,000. Lordship. So, since no action was taken, we filed a writ petition. And, my lord, in the writ petition, that, my lord, 33K of 2017. My lord, we filed a writ petition. Then, my lord, on the ground that we should be, our pay, our honorarium should be revised. Because, lordship, 1,500 is even much below the minimum wages. Your worship.
Yes.
Then, during the pendency of the writ petition. Then thereafter, lordship, during the pendency of the writ petition, the Honorable Supreme Court passed a judgment in case of home cards. My lord, home cards also similar. He sits at home and then carding VIP gets where VIPs and traffic duty whatnot. So the home cards from Himachal, Delhi, Punjab, he filed writ petitions and he approached Honorable Supreme Court for regularization of their services. My lord, you were not holding any substantive vacancy, similar like us, voluntary service. The Honorable Supreme Court, by a judgment, which reported in 2015 as 6 ACC, I'll come to the judgment later. He passed an order that since they are voluntary in nature and they are not holding any substantive vacancy, and the fact that as and when duty calls they are serving, they are not entitled for regularization of their services. But in the last para 39 of the judgment, the Honorable Supreme Court made an observation that since all these home cards were performing their duty, as and when they are called to perform their duty, they are performing the duty of a policeman. So, taking that into consideration, the Honorable Supreme Court gave a direction that though they are not entitled for regularization of service, they are entitled for 30 days pay of a policeman. Since on the day they perform, not the whole 30 days, but since on the day they perform the duty of a policeman, they are entitled for 30 days salary of a policeman. Accordingly, it was implemented. So, my lord, that's how in the home cards serving in Nagaland, their salary also was enhanced, revised to 30 days to a basic salary of a policeman. So, my lord, we also filed an amendment, additional affidavit before a single judge. That look, lordship, the petitioners have a long, my lord, honorable history. We are winners of Ashok Chakras. My lord, many of us over the years have sacrificed our life. They have been awarded Ashok Chakras, then my lord, presidential and governor calendar awards over the years because we're engaged in insurgency duties. In fact, we are first responders in the boundaries. So, my lord, we say, look, we are also similar in nature and we are performing the duty of a policeman as in when we are called for duty and the record will speak. So, we also should be given similar treatment. Accordingly, my lord, the learned single judge passed a direction, passed an order that within the period of 2 months, we should be given similar salary. It should be like the home guards. That was the direction. When we filed the writ petition my lord, we did not include Government of India as a party respondent because we feel that we are government, state government employees, so that it was not necessary. That was our understanding. Then, my lord, the state government filed a writ appeal. Now, during the pendency of the writ appeal, my lord, our honorarium was enhanced to 3,000 rupees with effect from, my lord, 1/4/2018. So presently we are paid 3,000 rupees honorarium. My lord, 3,000 rupees honorarium per month is also much below the minimum wages existing in the state of Nagaland as of today. That is what we are paid now. Now, my lord, the Leonard Division Bench, right, which on by judgment order dated 29/1/2021, my lord, modified the judgment of the Leonard Single Bench and says that, look, an expert committee has to be constituted, and the expert committee should examine and determine, one of the word used is not consider, examine and determine our eligibility, lordship, and thereafter, my lord, the direction was that thereafter it should be the expert committee, and one thing I'm missing, my lord. Now, before the Leonard Division Bench, the Leonard Division Bench deemed it fit that the Union of India should also be made a party respondent, because ultimately it is the Union of India who will reimburse the honorarium or expenses paid to us. And so importantly, before the Leonard Division Bench, the Leonard Division Bench, it had included the Union of India also as a party respondent. So, my lord, the direction was that the expert committee under the chairmanship, not less than chief secretary, not below the rank of a chief secretary, additional chief secretary, not below the rank of an additional chief secretary, a committee should be constituted where a representative of the government of India also should be made a party of that expert committee, and that expert committee should examine and determine. That is the exact word used within a period of 4 months from the constitution of the committee, and the committee to submit its recommendation to the state government as well as the government of India. And the government of India to consider and approve the recommendation. That was the direction. I'll come to the judgment. Direction is in the affirmative. It is not a question of please consider. It's a question of examine and determine, and government of India to consider and approve the recommendation of the expert committee. Lordship also kindly appreciate the fact that the members of the expert committee are not representing the government of India or government of Nagaland. By virtue of being an expert committee member, Lordship, they are to consider. In fact, that's how, my lord, though, my lord, some of them has been transferred during the pendency, I did not change or include any new party, because by virtue of being the member of the expert committee, not by virtue of the post you are holding, my lord, they are expert committee members. Now, what has happened is the COVID came and it was not implemented, so we filed a contempt petition. Now, when the contempt petition was pending before the Honorable Court, Lordship, the expert committee had 3 sittings. On the first day, the representative of the Union of India through video conferencing participated, but due to poor audio quality, he could not participate, and then in all the 3 meetings, he could not participate. 1. And the record will show that all the members also were not regularly present. Now, my lord, so what has happened is in the second expert committee meeting, he took a decision that he'll seek the opinion of the Union of India, MHA, on the issue. It's a clear case of abdicating the responsibility by the committee. So not the committee, but the Home Commissioner Lord had submitted the letter to the Secretary MHA that whether the state government should consider for enhancement of the honorarium of the village parks. Now, what has happened is, accordingly, a reply was sent by the ministry, by the Secretary to the MHA, Secretary to the Government of India, MHA, that in view of fund constraints, paucity of fund constraints, they are not able to oblige. That was the reply given. So, my lord, in the second and third, in the third meeting, when the expert committee was held, in the absence of the representative of the Union of India, the remaining members took a decision that since government of India is not willing to consider, he decided not to recommend for revision or enhancement of our honorarium, solely on the basis of the letter, the letter received from the Minister of Home Affairs. So, my lord, and thereafter, my lord, the respondent number 3, then the commissioner, who is the commandant, ex-official commandant general of village guards, my lord, he filed a compliance act. No other expert committee members or Union of India representative filed any affidavit. Accordingly, my lord, the issue was considered before the single judge of this court, before the contempt petition. On 5/12/2022, the single judge passed an order that the expert committee had not applied his mind, they have totally misunderstood the issue of the case, the issue at hand. So, my lord, the learned single judge in the contempt court on 5/12, by an order dated 5/12/2022, was an order that paucity fund cannot be a ground, and the paucity fund was not a ground in before the learned single judge bench as well as before the division bench, and this is the issue raised for the first time because affidavit was filed by the Union of India in the division bench, and paucity fund was not the ground taken then. So, taking all that, and so in that view of the matter, the learned single bench judge, by an order dated 5/12/2022 in the contempt petition, held that the letter received from the MHA is not reasonable, that cannot be considered, and on the basis of that, our case should not be rejected. Accordingly, my lord, and I also relied on the judgment of the Honorable Supreme Court, which says that partial compliance is no compliance. In that situation, the opportunity should be given for full compliance. So, relying on those judgments, lordship, the learned single judge give a direction that the committee to be reconstituted again and reconsider our case in the light of the judgment passed by the learned division bench, as well as the order passed on 5/12/2022. Thereafter, my lord, in compliance with that, the chief secretary to respondent number 1, my lord, the compliance order has reconstituted the expert committee. Okay, now the reconstituted expert committee, my lord, it clearly says that it was reconstituted in compliance with the order dated 5/12/2022 passed in the present contempt petition. My lord, that may kindly be appreciated. Earlier, the first was in compliance with the judgment of the division bench, the first expert committee. Now the second expert committee was constituted in compliance with the direction passed by this honorable court on 5/12/2022 by the learned single judge in the contempt petition. Thereafter, my lord, two meetings were held. Thereafter. In the first meeting, the chairman of the expert committee was absent. The representative from the MHA was present on the first meeting through video conferencing, and he simply relied on the MHA letter, saying that this is the style of the MHA, so we cannot. And if the state government is willing to give, we have no objection. That was the line, and that is how the affidavit is filed. Then, in the second expert committee meeting held, the representative of the MHA was absent. But since his views were recorded in the first meeting, in the second meeting, my lord, the learned single judge, the expert committee has simply, after expressing their reasons, various issues that we have discussed, the operative portion is he had, in view of the stand of the government of India, as in view of the letter, the expert committee has simply reiterated the decision of the first expert committee. That is rejecting our case for recommendation. Now, my lord, one thing I have failed to highlight is the judgment of the division bench says, well, the expert committee re-examine our entitlement. Paragraph 39 of the judgment passed in Gra Raksha, which I was mentioning, also has to be taken into consideration by the expert committee. That was also there. So, my lord, the compliance affidavit has been now again, the second compliance affidavit has been filed on the ground that the second expert committee has, for various reasons, this is the issue, and they have just reiterated the decision of the first expert committee. That is the position as on today. Now, my lord, the first question which Lordship has raised is, my lord, Lordship, can you allow me to read the Gauhati High Court rules? Appendix 282 will be the relevant portion, page 282. My lord, the Gauhati High Court rules start from 280.
Yes.
My lord, we are in 6.1 and 2. Every petition mentioned or reference in relation to criminal contempt shall, unless the Chief Justice directs it to be heard by a larger bench, be laid for motion hearing before a division bench of equitable judges. 2. Every petition, motion, or reference in relation to civil contempt shall, unless directed otherwise by the Chief Justice, be laid before a single bench. My lord, in that view of the matter, my lord, it was
Yes.
so that's how, my lord, I filed it before single bench. And my lord, now, my lord, this is second round of litigation. Because this. So my respectful submission is 6-2.
What does the contempt of court act says?
My lord, contempt of court is held on this. My lord, yes.
Contempt of court. Because my just doubt is that since single bench direction has been modified by the division bench.
Actually, your lordship is partial citizen. And fresh direction.
But
No, my lord.
I'm not saying anything, but
My-
the
my-
convention that is followed, that
My
is why.
respectful submission, I am only going by 6-2.
Right.
I'm going because convention limited, my lord. This is not the first time, my lord.
Convention means there must be something
My lord,
more. That I have not
my
studied.
lord, my lord.
That is what I am saying.
The point is, my lord, this issue has been raised by other honorable judges also. Here. Last time, in court number 2 also these issues were raised, but we simply said 6-2. Because, my lord, if your lordship can see contempt petitions, it is silent. My lord, your lordship can see.
Can I have a look at the division bench judgment?
Yeah, my lordship, can you see the rule number, the section 19? My lord, that also will throw light after contempt petition appeal. An appeal my lord, lordship, can you allow me to read? Appeals. 1. An appeal shall lie as of right from an order or decision of High Court in exercise of its jurisdiction to punish for contempt. 1. Where the order or decision is that of a single bench to a bench not less than 2 judges of the court. B. Where the order or decision is that of a bench to the Supreme Court. 19. No, besides that, my lord, since the
My lord, 2 weeks ago, similar case came up in court number 2 and relying on 6.2. Because my lord, conveyed practices may be there, but I have to go by the rule because besides that, I have not found any other provision.
In the High Court Rule 6.2 is
Yes,
quite clear.
and there is no objection from any side, lordship.
Okay, previous 6.2 is there.
Yes. Yes.
But I am not still convinced.
My lord,
Since in presence of 6.2, yes.
yes, because my lord, I also try to check, but then ultimately, my lord, the rules should stop. And that's how, my lord, that practice is followed here.
Okay. Now, where is the division bench judgment?
Yes. My lord,
Shall I have a
the
look?
division bench judgment is a page, my lord, starting page 16. My lord, can you allow me to read some paragraphs?
I'll just have a look at the operative part. How it-
Yes. Lordship, paragraph, the operative paragraph is paragraph 29, page 33. Very important.
What it has done with the single bench
My
judgment?
lord, I'm coming to that. I'm coming to that. I'm coming to that.
Okay.
My lord, lordship, kindly allow me to, at page 23, paragraph 14. Very important. The learned single judge, upon considering the case projected by the rebel parties, disposed of the writ issued by the Indian judgment in order dated 9/11/2017 by directing the state government to examine and raise the existing wages and allowance of the wages to a reasonable level, but not less than that of the home guards of the state within a period of 2 months from the date of receipt of the judgment in order. The learned single judge further directed that the increase in wages of the allowances should be made effective from 1/1/2017, that thus being highly agreed, distant respondents have filed the instant appeal. Then under paragraph 15, mention will be made here that when the writ appeal was taken up for admission on 7/2019, this court was of the view that the Union of India and the Ministry of Home Affairs would be a necessary party. As such, the Union of India, represented by Secretary Northeast Division, Minister of Home Affairs, was made a party respondent of the 17th writ appeal. Accordingly, notice was issued to the respondents and the respondents in the respondent number 7 in response to the notice had filed an affidavit in opposition of 23/1/2020. In response, the state appellants had filed an affidavit in reply on 2/3/2020. Then also may kindly come to page paragraph 29. In that view of the matter, we direct the state government
to constitute an expert committee to examine and determine the payment entitlement of the financial benefits of village cards in consultation with the Minister of Home Affairs, Northeast Division, Government of India, New Delhi. The expert committee should include representatives from the Home Department, Department of Personnel and Administrative Reforms, Finance Department, at least 2 members from the Petitioner Association, representatives of the Minister of Home Affairs, Northeast Division, amongst others. The committee should be chaired by an official not below the rank of Petitioner Chief Secretary to the Government of Nagaland. The committee would be constituted as directed here in above within a period of 3 weeks from the date of receipt of a certified copy of this order. And the committee should complete the process of examining the matter of enhancement of the honorarium in other allowances of the species as expeditiously as possible, and not later within a period of 4 months from the date of from the date is constituted. Well, considering the matter of enhancement of honorarium in other allowances as directed here and above, the committee shall take into consideration the observation and direction given by the Apex Board in paragraph 39 in the case of Gra Raksha Home Guard Welfare Association Supra. The recommendation by the committee shall be forwarded to the state government in the Home Department and also to the Ministry of Home Affairs for approval and further necessary action. The impugned judgment is hereby set aside. So, my lord, single bench judgment, single bench direction was without an expert committee to directly give us within a period of 2 months. Similarly, like the home cards in terms of the judgment. But the learned single judge in appeal, the division bench said that an expert committee be constituted. It is not total rejection. Expert committee be constituted. Now, my lord.
The division bench has substituted his views,
Yes,
setting aside the single bench.
yes. Now, my lord.
There lies the cracks. Anyway,
Yes.
6-2.
Now,
But I am still not yet convinced. Somehow, 6-2, though it is said,
yes.
but somewhere, some lies something.
My lord,
I don't know.
my lord, that on that issue, we also have verified from the registry
Yes.
earlier.
Hmm.
Because, my lord, this is not the first round.
Hmm.
But besides 6-2, my lord, you could not satisfy us, and lordship may kindly appreciate this fact. Suppose there are, whether, let us presume that there are some administrative instructions issued. But when there are those.
No, that cannot be. That cannot be. That cannot be, but still bothering me. I am not saying that
Yes.
this 6-2, but why then? Under what this rule has been prepared?
My lord, this is the.
In exercise of power?
Something of 4 Gauhati High Court rules 1977.
23 of the Contempt of Court. Constitution of India. Constitution of India.
Yes. Okay, we can see. The rule 23 of the act provides the High Court to make your own rules, and so we have made our own rules, my lord.
Yes.
That is the issue.
Okay.
Now, my lord, paragraph 29 of the judgment. My lord,
Yes.
it talks about 4 days. My lord, expert committee to examine and determine. Secondly, expert committee to be constituted not below by the chairman, not below the rank of a chief secretary. 4 months from the date of, it is to consider 4 months from the date of that it is constituted. Then take into consideration the observation and direction of para 39 of Pra-Raksha judgment. And fifth is forward to the state government and Minister of Home Affairs for approval and further necessary action. That is five elements are, 5 points are involved. Examine and determine Chief Secretary, 4 months, paragraph 39. Then forward to the state government and MHA for approval and further necessary action. My lord, till date, my lord, I'll satisfy from the lecture report. Till date, the last 3 lines, the recommendation made by the committee shall then be forwarded to the state government in the Home Department and also the Minister of Home Affairs for approval and further necessary action. That has not been done till date. Now, my lord, Lordship, may kindly allow me to-
No, as per your submission, the expert committee has not yet determined the payment.
That is the point. That is the point.
As per your submission,
Not determined. So, my lord, that is why I'm saying, since it has not been determined, it is yet to be submitted.
that is the next
Yes,
step.
exactly. Your lordship has, I agree. Now, my lord, before we go further, kindly allow me to refer to para 39 of the judgment, paragraph action. My lord, 2000. My lord, 2015, 6 SCC 247. My lord, kindly allow me to read para to appreciate the facts, issues. Kindly allow me to read from para 33 to 39, the last 2 pages.
Yes.
In the cases before us, though some of the home guards produced their appointment letters to show that they were serving as Blacklin Havaldar for 10 to 28 years, we find that they have been enrolled in there is no appointment on regular basis. They have never been paid salary wages and there is no provision to make any payment salary other than duty allowance and other allowances. In the form filled up by the home guards, volunteers of each state, the home guards have specifically mentioned that they undertake to serve as member of the home guards at any time in place if they are called for training or duty. It is evident from Form 1 of the Himachal Pradesh Act of 1968, which shows that they are entitled for temporary allowances. And in case of injury sustained or disability occurred during the duty, they are entitled for disability pension. Similar is the case of Bombay Village Guards. 36. The home guards of in city of Delhi have also provision to the organization which is volunteer body under the Act. I'm skipping that. 37. It is not the case of the whole village state government that enrollment appointment of village home guards are backdoor engagement and illegal made in violation of 14 and 16 of the Constitution of India. Therefore, the decision of this court in Gauhati is not applicable in case of applicant home guards. Admittedly, there is no concept of wages. These volunteers are paid duty allowance and other allowance to which they are entitled. There is nothing in the record to suggest that they perform duties throughout the year. On the other hand, it is a specific case of the state that as and when there is requirement, they are called for duty, otherwise they remain in their homes. Therefore, in absence of any detail about continuity of service, month-to-month basis or year-to-year basis, the duties and responsibilities performed by them throughout the year can neither be equated with that of the police personnel. In view of the discussion made above, no relief can be granted to the appellants either for regularization of service or for grant of regular appointments, since no inference is called for against the judgments passed by the Himachal Pradesh, Punjab, and Delhi High Courts. However, taking into consideration the fact that the home guards are used during the emergency and for other purpose, and at the time of their duty, they are empowered with the power of police personnel. We are of the view that state government should pay them the duty allowance at such rates, total of 30 days. A month comes to a minimum of the pay to which police personnel of the state are entitled. It is expected that the state government shall pass appropriate orders in terms of aforesaid observations at an early date, preferably within 3 months. That's how, my lord, in the state of Nagaland also, they were given this benefit. So the best is well performing their duty, whether they are empowered.
Basically, here it is a case of honorarium.
Yes.
Is it
Honorarium.
not?
Basically, it's a case of honorarium.
Monthly honorarium.
Monthly honorarium. Now, my lord, to substantiate the issue, my lord, this is a document which was annexed in the writ petition and as well as the writ appeal. The forwarding of it will my lord, lordship, the type copies, lordship, it is, lordship, you can see the type copies from the 3rd pages. My lord, if your lordship kindly read the whole, my duties will be proposal for revision of wages, increase in honorarium for village cards, personals in Nagaland. My lord, this was annexed F in the writ petition as well as writ appeal. On the subject cited above, I have the honor to submit herewith a proposal in respect of village card organization Nagaland as per the discussion during your recent visit to Nagaland. The duties, the rules and duties of villages are primarily for assisting the police in curbing criminal activities in apprehending criminals within their jurisdiction. They also make the role of first responder during natural calamities for which most of them have been trained. The VGs also assist the district administration in maintenance of law and order in villages, with protection of the village, performing RP duties for VIPs, counter-insurgency operations, guides, performing election-related duties, parade contingency, bagpiper band in the national day celebration, round-the-clock security in their respective villages, guarding the porous international border of Myanmar. There has been increased activity of underground element along the international boundary for which VGs have to be extra vigilant. The services of the VGs are also extensively used by the security forces as guides. The total strength of VG personnel is 9,583, and they are posted in 5 districts. Now, my lord, it is district 6 because the block under 27 is now a new district. Spreading under 320 posts. The village organization is headed by the Commissioner Nagaland, ex-officio Commandant General, who is assisted by the Commandant of IPS Cadet, stationed at Tonsam, 2 deputy commandants at Monty Free, and 10 assistant commandants. Since the inception, the VGs are playing a very prominent role in strengthening and improving the overall security environment in the bordering area of the state. The contribution of the VG personnel thus in furthering the national interest is outstanding, and any step towards improving their capabilities and confidence in any manner should be highly appreciable. As such, Ministry is therefore requested to kindly examine the matter for consideration and necessary action for revisions of wages increase in honorarium from the present 1,500 to 5,000. So, my lord, just to highlight, my lord, what we are performing. This is a letter written by to the Chief Secretary by the Home Department of Nagaland. On 30th May 2016.
Now, what I could understand, subject to single bench exercise jurisdiction, whether after that subsequent order.
Yes, I'm coming to that thought.
I'm just
Yes.
wanting to that from the text and tenor of paragraph 29.
Yes.
This expert committee has to examine and determine
Yes.
without being subject to any views
Yes.
of any other authority.
Exactly.
They have to come to a determination
Yes.
as to what is the village girls should be entitled to.
Yes.
Thereafter, the next steps.
Yes.
But without being influenced by any other external
Exactly.
factors.
Exactly. That is the issue.
That is what now committee is in existence.
One of the issues like this. Committee has submitted the committee submitted the report.
Then you have said Ministry of
That-
Home Affairs.
Then secondly, Lordship, the second committee that has been constituted has simply reiterate the report of the first committee.
That cannot be.
So, my lord, and thereafter, my lord, so, and this has, it is reiterated, so the issue is, my lord, at this stage, whether the chief secretary should be further correct. Because, my lord, further directed to constitute a no new committee. My lord, I'm coming to that. I'm coming to that.
Yes, yes.
Now, my lord. Lordship, I filed an additional affidavit. Now I'll show the documents, how it was influenced externally, how the committee were externally influenced.
Because they should confine themselves to this thing. That what are the roles of the village guards and to perform such duties. What honorarium should be paid to them?
Exactly.
That is simple.
It is only recommendatory.
And they will only say that we have reached a finding that this amount should be payable. Thereafter, the Ministry of Home Affairs will consider, not
Exactly.
before that.
Exactly. Now,
This is my view.
till now.
First, the expert committee, without being influenced by any other factors,
Exactly.
only taking into account the roles and responsibilities discharged by the village guard
Exactly.
and the peculiar situation existing in Nagaland,
Lordship.
what honorarium should be paid to them.
Yes.
This is our determination. Thereafter, it is for the Ministry of Home Affairs, as per paragraph 29, to consider,
Yes.
then approve.
Exactly.
So consider includes some amount of negotiation or cutting also,
Exactly.
but not before the
So,
determination by the expert committee.
so what has happened so far?
But before putting the horse,
Exactly.
putting the cart before the horse.
Exactly, Lordship, that is your Lordship has hit the bullseye.
That is what I find.
Now, what has happened?
If the submission of Mr. Takamasa is correct, subject to.
Well, I'll show from the records.
No,
I'll show from the records.
primacy, it appears to be the case,
I'll-
without going into the case.
Yes, I'll show from the report.
Yes, Mr. Jamin. That expert committee has not determined yet whether determination is there or not. What is the meaning of determination? Any
Yes,
dictionary?
in simple, in common parlance,
Huh.
determination means to decide,
Decide,
to settle.
settle.
Supposing when we say that this issue has been already determined by the Honorable Apex Court, it means that the issue has been already settled.
So expert committee is entrusted with the duty to
Examine,
travel to the first mile post.
examine.
First mile post.
Examine.
Examine and determine the
File post. Yes.
mile post.
Your Lordship is right.
Thereafter, the travel to the next mile post will,
And the first post is, Your Lordship, to examine.
yes,
And examine in the context of para 29 of Grarash,
okay, that will consider.
whether that will come. So
And plus, that cannot be a main factor.
No.
The factor is the roles and responsibilities discharged by the village guard. That is the prime factor.
Yes, Lord.
Then that will take as a guidance, village guard.
So, Your Lordship, in my affidavit of opposition, I have given a complete chart of the village guard. and the home guard.
No. Whether the expert committee question is whether expert committee has determined or not.
Yeah, that's examined.
Examine, they are going on examining.
Thereafter, Your Lordship, if they have determined that no, at this stage,
No, no.
they don't come. within
Cannot
the
be
purview.
say, indefinite.
Yes,
The division bench has said this 4 months.
Yes.
Yes.
4 months has
Yes.
expired long back.
within 4 months, there was a delay of 6 days.
Well,
There is a delay, I will satisfy Your Lordship.
No, whether they have determined or not.
No, it was decided, it was set there after examining the role of the village guard and the home guard, a comparative chart I have given, Your Lordship. They had decided, no, since they don't come within the purview of 29, Garaksha. So,
No, Griroxog is secondary.
exactly. Exactly.
Division bench has said, what, let us see, examine first, please. They will, that will be a guidance. But firstly, you have to independently determine Please again, come to 29 again,
Yes.
if I understood it correctly, I don't know.
Your Lordship,
In the,
your- your Lord-
in a contempt petition, right?
In the content.
While considering,
Yeah.
while considering the matter of enhancement of honorarium, that enhancement is inbuilt,
Yes.
Your Lord.
right?
Yes.
That while considering the matter of enhancement of honorarium and otherwise, the committee shall take into consideration the observation.
Yes.
Your Lordship may.
So firstly, their determination as regards enhancement of honorarium,
Yes.
right? And while arriving at the first milepost, you also take into consideration the observation made in paragraph 29 of Griha Rakshak. That is what?
Your Lordship may kindly come to para 14, division bench, page 23. What was the direction of the learned single judge? Page 23, para 14.
Firstly, the enhancement of honorarium is inbuilt.
But to consider.
Please.
Consider whether and how.
No.
Because.
Let me find out the word determination. It appears to be a dilly-dallying tactic. To ascertain or
To settle.
just complete the meaning. To ascertain and establish exactly by research or calculation.
So it's inbuilt.
Inbuilt. And plus this word,
Your Lordship may.
while considering the matter of enhancement of honorarium, you take into consideration the Griha Rakshak. Now, have you calculated exactly?
No.
Huh?
Your Lordship may kindly come to para 14, kindly, Your Lordship, page 23. The judgment passed by the learned single judge, what was the direction?
But he claims
No,
that he set
no.
aside, so what places is going to become sufficient?
Why it was set aside? Because the direction was, the learned single judge direction was to examine and raise the third line. And there's a difference between, the connotation is different. Examine and raise, examine and determine is different.
Okay, determine. This is the meaning.
Now,
By research and calculation, you
Well-
come to a figure exactly. That is what?
in my respectful
Ah.
submission, Your Lordship, in my respectful submission, while the Honorable Division Bench has directed, it was not a positive direction to enhance, but to consider.
Okay, determine. Come to the exact position.
So,
That you can come to 1000 also.
no, but then in the first condition exam, first post is graduation. Whether.
Oh,
that
no,
can
no,
be
no,
done.
no, no, no.
That is my.
No, that
submission,
is
Your
not. That is not. That is not.
That is my submission, subject to what your Lordship says, Your Lordship. So I have to first, a comparative chart I've given in my affidavit of opposition. Your Lordship, the function, the duties, responsibility discharged by the village guard
See, we,
and the home guard.
it is also settled that we, in the contempt jurisdiction, we cannot go beyond the direction given by the court,
Your Lordship.
right? Now, to determine, you may take rehearsal, whatever. But you have to determine
Yeah,
to reach the milepost.
the conclusion.
Yes, conclusive, 1000, 2000, 3000, 4000, whatever. Then they have to come again with a writ petition.
Yes.
See, Mr. Zamir, that determine, examine and determine. You have to determine the expert committee. I'm not saying about Ministry of Home Affairs or Government of Nagaland. I'm not saying. I'm saying the expert committee has been entrusted with the task to examine and determine. And while determining, you take into consideration gross. Because the fact of the matter is that they are being paid a fixed honorarium already. Right? Expert committee may come to a conclusion again at 5,000 also. But you have to come to a conclusion. That is what you take into Grihoraksok. You may say Grihoraksok is not applicable, whatever. But you have to determine and come to reach the milepost. That is as simple as that. Thereafter, the other things may follow. By the time expert committee reaches say 5,000, maybe 6,000. But that is what the division bench is saying. We cannot say 5,000, 6,000. It is the expert committee who has to say. Thereafter, Ministry of Home Affairs will consider.
Yes, and approve.
And consider they have the discussion now.
Yes.
They will have the discussion that we may not agree. They may not agree. But here it is a cart before the horse. You are independent. You are independent. You are representing the expert members.
Lordship.
You are independent. You cannot be influenced by anybody.
I am representing R2.
Oh, whatever.
Other they are.
But all, he's the chairman, he represents the chairman of the
I
expert
represent the
committee.
chairman, the others are all members.
Oh.
No,
But our understanding was lordship.
I will go by the dictionary meaning of determination.
Lordship.
I think Oxford dictionary is correct.
yes.
Lordship.
I can't-
My thing is that
Ah.
determination.
I am very weak in English, but at
Law.
least
My
I can-
understanding is determination is to settle.
settle. That is what.
Settle, yes.
That is what.
And you examine.
Determine, ascertain or establish.
Yes,
Exactly.
yes,
By research.
by research, whether they
Or
are
calculation.
whether they are entitled
Research takes into fold the Grohrox.
to, yes.
Yes, and calculation.
Yes,
And
calculation.
whether they are examined and
Determine.
settled, whether they
No,
are
but-
entitled to enhancement.
One of another,
Entitled, you may come to a conclusion, Mr. TV Jamir, you are independent and free to come to a conclusion. No, only 5,000.
So
See.
that is the conclusion where they are not entitled to enhancement, but they are entitled to
No.
other benefit.
that is not the subject matter of the direction, not
That
only
is-
entitlement.
That
it's not an issue.
recommendation,
It is not an issue. We have never prayed for other entitlements.
that is a
No,
report.
no,
And
where
don't
is,
you the-
where is your report then?
Report.
No, Manoj,
My affidavit in opposition,
yes.
Lordship. At page. Starting from page 97, affidavit in opposition.
By whom?
97,
Filed by whom?
yes.
Visili Kejo?
No, your lordship, but my affidavit, I filed on 6/9/2023. Affidavit in
6/9?
opposition, 6/9/2023.
By
Our
Sentianger in
lordship,
Lordship, may
page
kindly-
97.
Lordship, may kindly see the recommendation is 101. 101
101 of?
of the report.
Of that. See,
After-
No, I am not getting it.
uh,
Affidavit in opposition by whom?
respondent number 2, Sandhyangar. Your
One.
lordship has got it. Lordship
No,
has
no.
got it. Page 100,
1 minute.
starting from page 97.
Sentianger in
Lordship,
Chen.
lordship,
Lordship, may
lordship.
kindly see the operative at 101.
It sta-
101.
it starts from 97. Report. And 100 page 100 lordship may come. The recommendation by the reconstituted expert committee,
Hmm.
page 100. Lordship has got it.
Yes.
So this is the recommendation, your lordship. So I don't know why the petitioner is saying that recommendation, no recommendation
Yes.
has been made.
Yes,
Like, of course, enhancement was not made, but then there are some benefits, whatever benefits can be given, that recommendation was given, your worship. But honorarium, not enhanced, your worship. And this recommendation is made based on the report para 5.
My lord, the last 2 lines.
What is the view of the earlier committee?
Lordship, the earlier. My lord, the earlier 116. My lord, which 114 is the earlier committee report.
That page 100A, recommendation of the previous committee.
Yes. Yes. And my lord, at 116.
116?
Yes.
No, second committee has simply reiterated the
Yes.
views
So
of the first committee.
Yes, the first
Now-
committee report is 116.
First committee report is
It's
116.
116.
And where there is reflection that is influenced by the Ministry of Home
I
Affairs.
will show from the minutes. I'll show from the meeting minutes, Lordship. And Lordship, you kindly see, Lordship, you kindly allow me to read the whole paragraph from 115.
Hmm.
In the committee had a total of 3 meetings, the last being 31st January 2022. In view of the pandemic, the ministry representative of the Minister of Home Affairs would not attend. However, the views and comments of the government media MAG was communicated by chair letter dated 14 December 2021. The members representing the Village Card Association also present your views on the rules played by them during official duties on gathering information regarding international orders, providing intelligence outputs, etc. Reiterating that your duties and activities are at par with the police and request to the committee to enhance the one-time provident fund and also look into the matter on humanitarian grounds and also submitted representations which were duly examined. The number representing the Home Department listed out 3 demands of the digit enhancement, entitlement of pension families and other facilities like medical and life insurance. The committee also took the view of the Law and Justice Department in being here relating to observation direction given by the such and such. The views of the MAG as contained in the letter mentioned above also was into consideration. The committee examined and deliberated the issue at length. From the materials and facts at hand, the committee was of the view that village cards are basically a voluntary force and their mode of recruitment and training was different from that of home guards and therefore cannot be treated at par with them. However, as the main chief are employed in security and disaster related issues, we perform duties similar to that performed by the home guards on question of increase of honorarium MAG as expressed. Inability since the same was enhanced from 1,500 to 3,000 only in 2018. In view of the reason elaborated above, the following are recommended. The committee does not recommend increase in honorarium of the wages at this juncture. As and when wages are deployed for duty outside your village, you should be paid allowance and power with home guards or that of equivalent to minimum wages, particularly provisions made available under Russian and TA department for the same in Commandant General should work out the modalities. As far as the other benefits are concerned, Commandant General should work out the package by leveraging the welfare fund which is already in operation for the wages. Now, Lordship, we kindly appreciate this fact. This committee report was rejected by the learned single judge by the order dated 5/12/2022. My lord, since I'll submit the second Lordship. Only those minus reports, how it is influenced.
Mr. Lordship, if I'm allowed to mention item number 19, Lordship. On behalf of the Lordship, I'm yet to receive instructions, so kindly permit 2 weeks time, Lordship.
19,
Lordship.
Mr. Jose Hotel, learned counsel for the petition is present. MSL Chang, learned counsel for the learned deliberations. Paying for the state respondents has submitted that the necessary instructions to file counter affidavit are yet to be received. And has thus paid for how much time?
2 weeks, Lordship.
3 weeks time to file, obtain necessary instructions and to file counter. The praise allowed is the case after 3 weeks.
Lordship, similar prayer for item number 23, Lordship. On behalf of Inawati, Lordship.
Mr. Jose learned counsel for the petition is present to stop. On the prayer of Ms. Chang, learned Union Government of Nagaland, representing Mr. Inaholi, Learned State Council. Please the case after 3 weeks.
I bring Respondent number 4.
Okay, Mr. Fossil Bote and Mr. Joaquin Richabo, Learned Council for the Respondent number 4. Are present. Okay, full stop. Mr. Joaquin Richabo, Learned Council for the Respondent number 4 has also prayed and is granted, has prayed and granted 3 weeks time to file affidavit in opposition on behalf of the Respondent number 4. Yes.
Lordship, similar prayer for item number 26, Lordship, on behalf of Muslim Lordship. 26,
26.
Lordship.
Okay. Anybody else present? They have informed.
Lordship, Lordship.
Or the Council of the Learned Council for the petitioner, MS L. Chang, Learned Council, Learned Junior Government of Nagaland, has prayed for and is granted 3 weeks time to file, obtain necessary instruction and to file counter agreement on behalf of the state respondents.
Lordship, similar prayer for item number 17, Lordship, on behalf of Abitoli, Lordship.
Okay, with the consent of affidavit file or if it for affidavit? Affidavit file,
Does not
Vice-
file, Lordship. Will
Huh?
not file.
affidavit not filed.
The state are yet to file the.
Okay. Miss R. Achula Gibbs, Learned Council for the petitioners is present. Miss S. Chang, Learned so-and-so, appearing for Miss so-and-so,
Abitoli.
wait to Learned State Council. Wait. Necessary instruction not received. 3 weeks obtained to obtain counter necessary instruction to file counter agreement on behalf of the state respondents. Praise the Lord, is the case after 3 weeks.
Lordship, item number 16, Lordship.
16.
On, yes, Lordship, on behalf of, Inawadi, Lordship. Lordship, here, the weeks are complete, so if this matter can be listed for admission hearing, Lordship.
Okay. Anybody? It is submitted by the Learned Council for the parties that the exchange of pleading between the parties is complete and the matter can be fixed for hearing. Full It is the case for hearing accordingly in due course.
Lordship, item 21 is read.
21.
21, Lordship, on behalf of Muslim, Lordship. Lordship, even, pleadings are complete, Lordship, here.
Okay, same order. Mr. So-and-so, Learned John Welling and MS Chang, huh?
Lordship, hearing item number 28 to 37, Lordship, on behalf of Inawadi, Lordship. After 3 weeks, Lordship. I've taken the consent from the petitioner's council, Lordship.
MS Chang, Learned Council, State Council, appearing for Miss
Inawadi.
Learned State Council has submitted that. Has submitted, with the consent of the Learned Council for the petitioners, to list the cases after 3 weeks. Full stop. As the prayer is made, the consent of the Learned Council for the petitioners, list the cases for hearing after 3 weeks.
Lordship, I also like to mention item number 15, Lordship, on behalf of Abitoli, Lordship. Your Lordship state is already filed, Lordship.
MS so-and-so, Ashula keeps present. You have filed your affidavit
Yes, Lordship. State is already
and son.
Your Lordship, we won't be filing affidavit in reply.
Okay,
So I pray the matter be listed on 3rd of October.
as for provider Learned Council for the party, is the case on 3rd of. 3rd of.
Lordship,
Ah.
hearing item number 38, Lordship. If this matter can come after the vacation, Lordship.
38,
Lordship.
already mentioned.
Earlier it was 39.
Huh?
They made a mistake.
Okay. Repetition number?
132.
Okay, 132, huh? On the joint prayer of MS,
Assalamualaikum.
Asrangla Waling, Learned Council for the petition and MS Ed Chang, Learned State Council for the state respondents. the matter stands adjourned for 2 weeks. This is the case after 2 weeks.
Much obliged.
I pick to mention item number 27.
27,
Lordship, this matter will be listed after 2 weeks.
okay. On the prayer of,
Preparation of Lordship. Lordship, this honorable board, by its order dated 9/7/24, directed to take steps upon respondent number 5 to Gauhati as well as registered for.
yes,
Accordingly, I have taken the steps. The response number 5 has refused to accept. Private respondent.
private respondent, he is an employee of some office. Or what? Trigger filed.
My appointment last year, affidavit on 13/8/24.
Okay, we'll take note of that. The next date, you have already filed. Okay, Mr.
Manjukonya on behalf of my senior, Mr. Aizimur.
is present on the prayer of Mr. So-and-so, Team Chong, learned senior government, additional advocate general. Nagaland lays the case after 2 weeks.
Lordship, there's an interim order.
The interim order. Check Kulwa, if any, shall continue till the next date of listening.
Yeah,
Yes.
Lord, I'll show the documents going to show how the judgment was implemented and how the.
Before break, something was shown as regards by Mr. Jamir.
Recombination.
My lord, I'll show it because I'll be showing both. So to avoid repetition, my lord, because that is part of my duty to show the recommendation, but how it was constituted, how it was recommended, then lordship, I will try to show from the record. How the.
Is there anything illegal or contrary in the constitution of the committee?
No, only in the implementation, my lord, it is not an independent decision, but as lordship is right.
The question is, then my query will be whether in the contempt jurisdiction, rightly or wrongly, they have with the influence.
I will show you lordship.
No, since it has come into my, I generally express my mind.
My lord, I have, and whether, my lord, whether it will be a new course of action or not, this issue I will try to satisfy your lordship. My lord, I'm sure your lordship has asked the right question. My lord, to my contempt petition. My lord, at page 39A. My lord, the committee was constituted by the chief secretary in compliance. In pursuance of the direction of the honorable judgment such and such, the governor of Nagaland is pleased to constitute an expert committee with the following members. Then, my lord, representative from the MHA, my lord, terms of reference. The expert committee shall examine and determine the payment entitlement of benefits of village cards. 2. The committee shall take into consideration the observation and direction by the honorable subordinate such and such, well considering the matter of enhancement of honorarium in other allowances of village cards. The committee shall submit its report within 3 months. So this is the terms of reference given by the chief secretary, my lord, in terms of in compliance with the judgment. So, my lord, it is in terms of paragraph 29. Then, my lord, committee was constituted. Now, my lord, page 44A. In the first meeting, my lord, that I will only read the 2 lines. The representative of the Home Affairs attended the meeting through BC, however, owing to or out to his you will not be obtained. My lord, I'm skipping that just to save time, lordship. Then, lordship, we kindly see page 47. The Home Affairs was supposed to attend meeting through BC, however, could not be contacted during the pour out you and his you could not be obtained. Then, lordship, we kindly come to page 49. Same minutes. Further, after deliberation, the chairman opined that the members should be realistic in the approach on the matter of determining the payment entitlement of.
Page 49.
49.
Ah.
The same report. After further deliberation, the chairman opined that the members should be realistic in the approach on the matter of determining the payments entitlement of financial benefits of the village cards in Nagaland. This is the issue, man. Further, since the representatives of the Minister of Home Affairs were not able to take part in the meeting, owing to poor output and with you, it was decided to take up the matter with Minister of Home Affairs. That's how the influence came, for which the Home Department was asked to write to the government of India at the earliest. Now, my lord, thereafter, my lord, kindly allow me to refer to my additional affidavit. My lord, I have filed an additional affidavit, lordship, it is under, where do the written, my lord, an additional affidavit filed on behalf of the petitioners in the, as permitted by the order dated 12/5/2022. My lord, in the front page, in the matter of written, an additional affidavit filed by the petitioner by the order
When it was filed?
12. My lord, if you lordship may kindly see the front page.
Front page sometimes.
It was by order dated 12/5/2022, it will be written. It was filed in June 22. If lordship, we can raise it up, because in the first page, it is mentioned. An additional affidavit on behalf of the petitioners as permitted by the order dated 12/5/2022. Small one, lordship.
Small one.
Yes. In the first page.
Oh, it is, maybe it is. Huh?
Right, yes.
Check. Do yourself.
An additional affidavit on behalf of the petitioners in the contempt petition as permitted by the order dated 12/5/2022. Lordship has found it. No, lordship. Or
It runs into how many pages?
it runs to 20 pages.
This is 57 pages. 20 pages.
Or we can, if you find it difficult, I can, we can help,
Yes, Mr.
because it is quite bulky.
They are only the main contempt petition.
Oh, not, yes, but to save time, my friends. Extra copy from another friend.
Find out it is there or not.
Lordship, at page 12.
This kind of unit is not there at first glance. Yes.
Where is the letter? This is a letter addressed to the Secretary, Minister of Home Affairs, in compliance to the second meeting minutes. Narrate. On the subject cited above, I am to state that the government of India was kind enough to enhance the honorarium from 1,500 to 3,000. However, during the year 2007, the village card filed the BBC such and such in Gauhati High Court, and the state government was directed by the Honorable Court for enhancement of the honorarium to the villages to a reasonable.
This is, Mr. Takama said, let me find out or see this is completely, I cannot read anything.
The-
Please, Mr. Arenlong,
Yes.
please find out. This is completely, page 12 is completely illegible.
My sincere apology.
Take this page 12. Page 12, page 12. That copy is there.
Oh, my lord, I can give my copy.
Just one minute, Mr. Anilong, you can find out from him. Second copy. Okay. Yes.
I think this. That is the first copy. I'm only referring to the two letters. Paragraph, page 12, my lord, yes.
Page 12.
Page 12.
Yes.
My lord, this is a letter addressed to the Secretary Minister of Home Affairs, not to the expert committee member. On the subject cited above, I'm to state that Government of India MHA was kind enough to enhance the honorarium fund, which is in a from 15 to 3,000. However, during the year 2007, the village card filed a brief petition to WBC territory K of 2017, the Gauhati High Court, and the state government was directed to by the Honorable Court for enhancement of the honorarium to the VGs to a reasonable level, but not less than the home cards of the state. In view of the non-inclusion of MHA, which bears expenditure incurred in the payment of honorarium with VG, as responsible in the above mentioned petition, the Home Department appealed against the opposite judgment. The Honorable High Court, by order on one such and such, directed the Government of Nagaland Home Department to constitute an expert committee headed by an officer not below the rank of additional chief secretary to the Government of Nagaland to examine and determine the payment in the level of donation of benefits of VGs in the consolidated of MHA, and to further complete the process within a period of 4 months. The expert committee constituted had its first meeting on 3rd August 2022, where the members deliberated the issue concerns us meeting minutes. The second meeting was held on 28 September 2021. After thorough discussion and deliberation, it was decided to write to the MHA for its views and comments for enhancement of the honorarium. The following are the demands made by the VGs: enhancement of the duty allowance at the rate at par with the such and such, entitlement of pension schemes. Then 6, the expert committee after due deliberation is of the view that although the functions and nature of the village card are quite different with that of the village card, home cards in practice at times. The village cards under the supervision of the district administration and police have been performing various law and order and other security related duties in their respective village areas. Further mentioned in the method, they are also designated as frontline workers under COVID-19. The ministry is, in the light of the above, is requested to examine the proposals so as to enable the committee to come to a suitable conclusion. My lord, they are seeking a permission, paragraph 7. The ministry, in the light of the above, is requested to examine the proposal so as to enable the committee to come to a suitable conclusion. Then, my lord, next page is the reply. from the MHA. I am directed to refer to the government of Nagaland, letter such and such, and say that views of the representative of MHA and the expert committee have not been taken into account. Minister of MHA stand vis-a-vis the issue of enhancement, entitlement of initial benefits of VGs. A, VG are basically a volunteer village defense force by the government of Nagaland to help in order missionary in the rural areas of Nagaland, except when their services are required. The VGs are free to carry out their normal cultivation practices in other activities in their respective villages. VGs are appointed on recommendation of village council, mostly to guard their own villages and are engaged for other duties as and when required. Home guards, on the other hand, are recruited following due process and perform duties on regular basis and be posted in anywhere in the state. As such, VGs claim of parity with the MH home guards does not appear justified. The MHA under the scheme security-related expenditure reimburses 90% of the expenditure borne by the state government for deployment of VGs for security duties only. Despite severe budget constraints, MHA has doubled the remuneration paid to village guard from 1,500 to paid since 2000 to 3,000 with effect from 1/4/2014 as on date. 8,206 VGs of Nagaland are being paid by the MHA under the SC regulation. For the years 2021 and 2022, substantial funds have been released to the government under SRA, that is rupees 41.82 crores and rupees 30.35 crores respectively. Next, only to the state of Assam. Further, it is pertinent to mention that for the year 2020 to 21, government of Nagaland has been reimbursed an amount of rupees 26.68 crore for VGs only, which is approximately 64% of the total SRS reimbursement to the state. Therefore, it will be difficult for the MHA to enhance funds for payment of financial benefits to the village guards in the immediate future. Now, my lord, Lordship, may kindly come to my lord, page 8 to this affidavit. After receiving the letter from the MHA, the expert committee meeting was held on 31st January 2022 at page 9. It starts. My lord, paragraph, the chairman, Merrick. The chairman welcomed all the members and highlight the discussions and decisions taken in the previous meetings and requested the special secretary home to highlight and read out the latest views and decision of the MHA, an extract of which is reproduced below. Then the letter is extracted. Now, therefore, page 10. Therefore, the chairman requested the members to keep their views and comments on the matter and which are reported as under. The special secretary of finance highlighted that on the present economic scenario and financial position of the state, since the position of COVID lockdown, the financial position is not favorable. In view of the above, the present proposal of the VGs for further increase in salary at present is not possible. The Home Commissioner Nagaland was also stated that since the bulk of the expenditure incurred from remuneration of the VGs is being borne by MHA, and as they have expressed their inability to increase the same, it would not be possible to consider the proposal at present. The Commissioner and Commandant General VG also spoke on the same line owing to the inability of the MHA to increase the remuneration. The Secretary of Law and Justice also spoke with reference to minimum wages and wondered whether there will be any legal implications on the matter. The chairman opined that the concept of wages will not be applicable to VGs as they are on voluntary services and given fixed honorarium. The expenditure of the VG's honorarium is reimbursed by the MHA under security-related expenditure scheme, who have given their view stating their inability to enhance funds for payment of financial benefits to the VGs in the Nagaland in the immediate future. The member of the Nagaland village guards are being asked to give their views, requested to look into the matter sympathetically, though the MHA have expressed the inability to increase the honorarium at this juncture. After further discussion of the issue of enhancement of the honorarium of the VGs and other allowances as per demands, the committee agreed in principle to look into certain demands of the Commissioner and Commandant General. Demands and our entrusted to examine those demands and take the matter forward. These demands are enhancement of family provident fund, DTA allowance, ground up rewards, or heroic deeds. So, my lord, this was the decision. Then at page 16 is a report, which Lordship, my learned friend has earlier referred. This is the first committee report, on the basis of which, Lordship, my lord, I have read it out, so to my lord, paragraph 2, page 17 onwards, the direction of the MHA meeting has been read out, so to save time, I'm not reading again, but thereafter, my lord, the respondent number 3 filed an affidavit, a compliance affidavit. An affidavit on behalf of respondent number 3. An affidavit in opposition on behalf of respondent number 3, my lord. July 2.
An affidavit in compliance of?
An affidavit in opposition for and on behalf of respondent number 3. My lord, we can access it, lordship.
Yes.
Not with the time.
Yes.
Fine. It was.
1 minute, it may be there.
Yes.
An affidavit in opposition.
My lord, in the affidavit in opposition of respondent number 2.
Filed on?
My lord, it was filed in the month of July.
July.
15/7.
In the matter of an affidavit in opposition for and on behalf of the respondent number 3.
Yes, lordship.
Rovi
Yes,
Latu more.
I'll only read paragraph 5. Mary, my lord. That with regard to the statements in paragraph such and such, it wouldn't beg to state and clarify that expert committee wherein the representative of the petitioners are also members is seriously committed in examining the matter for necessary action. But owing to the imposition of COVID measures, since such and such, the meeting of the expert committee could not be held on partial relaxation of the lockdown measures. The first sitting was held on 3/9/2022, followed by second sitting on 28/9/2021. As the representatives of MHA could not attend physically, arrangement was made for video conferencing, but due to poor video and audio, his comments could not be obtained. As such, it was decided to write to the Minister MHA Government of India to obtain your view and comments. On receipt of the comments from the MHA, the third sitting was held on 31/1/2022, where decision of the committee was finalized. Therefore, the Home Department by a letter dated such and such submitted the report to the MHA for necessary action. So, my lord, it is a clear admission by the respondent that the decision was on the basis of the letter issued, direction issued by the MHA. Now, my lord, thereafter, the matter was listed before this honorable court, and lordship may kindly read the judgment order dated 5/12/2022 in the present contempt petition. Followed the issue whether from the record, not yes, from the records. 5/12/2022.
Yes.
My lord, I'm reading from paragraph 2. Kindly allow me to read the whole thing because everything hinges on this order. I'm reading from paragraph 2. The petitioners, may I remember?
Yes.
The petitioners who are leaches come before this court with a writ petition, praying for issuance of appropriate direction order directing the respondent to remove enhance their money honorarium, which was at the time 1500. When the petition was disposed on 19/11/2017, the court found the conclusion of the existing wage is too meager and deleted and directed the government to examine and reach the same to a reasonable level, but not less than that of home guards in the state. The conclusion in direction it appears was given by the court after taking into consideration several judgments passed by the Honorable Supreme Court on such issues. Being aggrieved, the state respondents filed a writ appeal, exceeding the judgment in order passed in the writ petition. In the process of hearing, MHA was included as a respondent number 6. After hearing the parties, the division bench directed the state government to constitute an expert committee to examine and determine payment and entitlement of initial benefits of VG in consultation with MHA. The expert committee, as per direction, was to hold constitute 8 members headed by a person not destined to post of additional chief secretary in a representative from MHA, a representative from the Home Department, Department of PNR, Finance Department, Commissioner and Commandant General, the representative of Law and Justice, President and General Secretary of VG. It was also directed the committee should consider all the relevant practices and observation and direction made in order itself in accordance in paragraph such and such. Thereafter, make a recommendation to the state government and also to MHA for approval and further necessary action. A time frame of 4 months was given to the completion of the exercise. Can you allow me to skip paragraph 3? It is the constitution of the committee. Paragraph 4. After the said notification was issued, the committee had their first meeting on 3/9/2021. The committee was attended by all the committee members except the representative of the MHA. The committee, after noting the absence of the minister of MHA, resolved that the law department should examine the matter regarding the claim of the wages vis-a-vis minimum wages prevalent in the state. And Commissioner Nicholas was requested to prepare a statement as how the wages association was conceived and their role and contribution in the system of governance in the state. Further, the Home Department Police B branch was asked to work out whether wages can be treated at par with Home Guard and prepare a synopsis detailing all the demands made by the VG organization for discussion in the next meeting. The next sitting was held on 28/9/2021. In that meeting, the principal secretary and the principal secretary PNR could not be present, and the representative of the MHA who was supposed to attend the meeting, though VC also could not be in the meeting due to poor audio. The meeting was, however, went ahead in their absence. The secretary law briefed the committee, also the Commissioner Nagaland, the subject topics instructed to them in the earlier meeting. Members of the VG who were present were also given a chance to making their submission regarding their duties in some of the activities that are already given to them. The representatives of the Finance Department give his opinion that the village guard should be paid here due allowance, keeping in view equal pay for equal work to the extent possible. So Finance Department was willing to give. He also proposed that the Home Department will calculate the operational system of the VG organization to keep up the case under security related expenditure of the state. The Home Department listed out 3 demands of the VGs and the enhancement of honorarium, entitlement of pension benefits and other facilities like life, medical and life insurance schemes. On further discussion, the Commissioner Nagaland proposed that for any heroic deeds and achievements, befitting rewards and awards can be given, as acknowledgement should be given to law and order duties and assignments, including ex gratia, and also proposed that retirement benefit will be increased from the welfare fund. But after retirement, we don't get anything. Now, the committee thereafter entrusted the office of the commissioner to work out the aforesaid issues and obtain approval of the authority concerned. Since the representatives of the Ministry of Home Affairs was not able to take part in the meeting owing to poor audio and video, it was decided that the matter can be taken up with MHA, and for that, department was asked to write to the government of India in such and such. Then can you allow me to skip the 2 letters? It is enclosed. Why not?
Yes.
Then since no order or notification has been issued by the respondent, which hence the monthly emoluments of the petitioner in the light of the 2 judgments by the single judge in division, the petitioner come before this court once again by filing the present case. My lord, I am skipping paragraph 5. That is my submission. Then paragraph 6, my lord, this is relevant. Kindly allow me to rely on TV Chamir's submission. Mr. Chamir, counsel appearing for such and such. In paragraph 5 of the affidavit, which I have just read, respondent number 3 itself submitted that though the committee was constituted consisting of 8 members, including a representative from the Ministry of Home Affairs. The representative of the Ministry of Home Affairs, for one reason or other, could not be present, and his leave also could not be obtained through VC through though efforts were made. Thereafter, a letter was sent to the MHA for obtaining the same. As per their view, received through a letter dated 14/2021, it appears that when MHA is not willing to enhance the money honorarium of the village guard to paucity of funds. My lord, this is the issue. Therefore, the state respondents, including the respondent number 3, could not take forward the matter to meet the directions given in the writ petition and in the writ appeal. The Jamir further submits that respondents number 3 and the other state respondent, at least on your part, have tried to comply with the direction given in the writ petition and writ appeal, but have fallen short in full compliance because of the view expressed by MHA. Therefore, if this court in its wisdom feels the respondent should further comply with the direction given, the state respondent will be given another chance to the same. Thusly, submitted that by constituting the committee and by conducting the meetings, the state respondents have shown that they were willing to comply with the direction given in the writ petition or the writ appeal, and no willful disobedience has been committed by them. Besides, having submitted as stated, but such and such submitted that also that in this case, board directs the respondent to continue to take appropriate actions as required in terms of the direction. The state respondent will be given some time to reconstitute the committee. I'm reading paragraph 8, madam. From what has been stated above in the contents of the minutes of the meetings and action taken so far by the state respondents and respondents number 6, it appears that the direction given the writ petition and the writ appeal have not been gone in depth to understand the same in their implications. Further, from the steps taken so far as may have been seen from the meeting minutes, it appears that there is a lack of concern and wholeheartedness in dealing with the issue. The appellate court directed constitution of the committee so that the issues involved in the implication thereof are deliberated thoroughly so that the representatives of the village cards whose services have been acknowledged and applauded, meaning including the President of India, may be settled in equitable and just manner. These are the people as per the reports who have been awarded 1 Ashok Chakra per class 1. 8 Ashok Chakra, class 2, 5 class 3 Ashok Chakra, besides other awards. From the letter of the Ministry of MHA, it appears that the judgment passed in the 2 cases have not been used at all, and therefore have refused to grant any more benefit to branches on the ground of paucity of fund. Paucity of fund was never an issue before the writ court and before the division bench. In any case, paucity of fund cannot be a reason for denying entitlement, especially to village persons like village cards whose services have not been duly acknowledged but applauded with so many awards and citations. People who are serving the country in difficult places in difficult times should be given their due because their services keep the people of the country safe and sound. It must also be remembered that the people of this kind of group hardly bring their grievances to higher authorities for redressal. Most of the time, they keep quiet, but only after compelling circumstances become forward to plead their grievance. Therefore, people in authority who are concerned with the affairs of such persons should be more sensitive or sensitive enough to attend to grievances at the earliest without giving any further or without pushing them to the wall. From the records as stated, it appears that the state respondents have taken some steps. Therefore, this court is of the view that they have at least deliberately not deliberately ignored or neglected compliance of the direction. Therefore, the respondents is once again directed to reconstitute the committee in the light of the submission made by such and other counsel representing the other parties within the period from 1 month to after being constituted. The committee shall take a deliberation or deliberations and determine the benefits to be given to the petitioners in terms of the direction given the writ petition and the writ appeal. The whole exercise should be completed within a period of 4 months from the date of the constitution of the committee. The chief secretary shall thereafter file a compliance affidavit. My lord, chief secretary is respondent number 1. He is yet to file the compliance affidavit till date. Now, lordship, in compliance to this, lordship, I'm going to the affidavit in opposition of respondent number 2, the thick one. Which was referred. CDR's lordship.
File on
6/9.
2000.
2023. Malo, that will be the thickest one. Lordship, I'm going straight to page 64.
Yes.
Accordingly, my lord, the second expert committee was constituted, which is the
Subject matter for today's deliberation, Lordship. In one more, this is a notification dated 28 February 2023, and pursuant of the direction of the Honorable Court in this order dated 5/12/2022, passed in contempt petition such and such. My Lord, I'll kindly allow me to now, Lordship may kindly see this notification was issued in compliance with the order dated 5/12/2022, passed in the present contempt petition, the single bill judgment which we have just read. Then, my Lord, terms of reference. The committee shall examine the matter pertaining to the nature and duties in all the related retirement matters of the Witches vis-a-vis Bongards. The committee shall also examine and compare the pay allowances of Witches vis-a-vis Bongards. Nagaland in the light of direction given by the such and such. The committee shall deliberate and determine the benefit to be given to the petitioners in terms of the direction given in the rate appeal, petition and rate appeal filed by the concern. The committee shall submit its report within the period of 3 months from the date of this notification. This supersedes the earlier notification. So this is the second expert committee. Now, Lordship, kindly now a question. Lordship, with the question that the Lordship has raised now. Whether when the order dated 5/12/2022 was issued by the learned single judge, whether the learned single judge has traveled beyond the order of the division bench, my Lord, and my Lord, what kind of an orders to be passed by the learned single judge to ensure compliance? Now, my Lord, my respectful submission, relying on the judgment of the Supreme Court has duty to issue, the contempt court has duty to issue appropriate directions for remedying or rectifying things done in violation of orders, which may include, which will include restitutive measures at any stage of the contempt proceedings. My Lord, I'll only submit a judgment there. Now, my Lord, 2015 8 SCC 163. My Lord, I'll be submitting 3 judgments here. My Lord, can you allow me to read paragraph 4 first? Mary, my Lord, just the complainants are being agreed by the partial compliance with the judgment order dated such and such has filed this contempt petition. My Lord, just that much. Then Lordship may kindly allow me to come to paragraph 10.
Yes.
My Lord, that the senior counsel for complainant has submitted the purport of the judgment in order of the High Court, and this court is not a compliance. Complainants were entitled to regularization imposed from 1981 from the date they have been appointed as junior engineers in the Department of State Government of Jharkhand, and said posts of the complainants have been upgraded to assistant engineers by giving them promotion here pursuant to the cabinet decision. Therefore, he has prayed that they are entitled for regularization into the post of 1981 from the year to be initially appointed to the same post and not from 1987, as has been identified by the respondents in the aforementioned notification, as sent the said amount of full compliance with this course correction issued with judgment order as been submitted by the single judge. And then, Mr. Such and such for the respondent says so to justify the compliance affidavit in the notification produced along with the affidavit by contenting the direction given by the High Court and this court in its operation portion of the order is that regularization of the complainant service in the post of assistant engineer must be done by the respondent and has been same be complied by them. He has further commented that there is neither any specific prayer nor any direction in the judgment of the single judge or a division bench of the High Court directing the respondent to regularize the service of the post from the year 1981. Then Lordship may kindly come to paragraph 16. One of 14 to 19 will be relevant, but I'm reading only from 16 to save time. May I read from paragraph 16? The learned senior counsel on behalf of the respondent is contended that there are not neither any pleadings nor any specific petition filed the complainants nor any specific direction for given the judgment in order of the high courts, as well as this court, the respondents to regularize the service of the complainants with effect from 1981. The said condition cannot be accepted by this court for the reason that it is contrary to the report, and therefore the same is wholly untenable in law. Paragraph 17. However, in our considered view, the reliance placed upon the judgment in order of this court, as well as high courts, as well as this court, does not support the condition of the complainants for the reason that there is willful disobedience on the part of the respondents, as they have partially fulfilled the direction given by this court, as well as the high court with regard to the realization of the service of the complainants from the year 1987. Further, however, further direction is issued to respondents to regularize the service of the complainant from the date of their initial appointment as junior engineer from the year 1981, non-compliant with the direction issued by this court from the above mentioned here would amount to violation of the legitimate rights of the complainant as determined by the High Court. After taking the entire litigation, the pleadings, the documents on report, and the legal completion urged on behalf of the parties in the consideration, we direct the respondents to comply with the opposite direction after properly understanding the purport of the judgments and orders of the High Court as well as this court. For this reason, we keep one more opportunity to respondent to complain with the judgment in order in total for regularization of service of the complainant from the year 1981. The same cannot be treated as a fresh direction issued in the contempt petition. The respondents are indicated the purport of the authority portion of the judgment in order that the High Court as by this court. The respondents shall comply with the order as indicated above and submit to compliance within 4 weeks from today. This was the judgment I have relied before the single bench in the contempt petition. Then the second judgment, Lordship, 2017, 5 SEC 506. My lord, the relevant paragraph will be paragraph 1, paragraph 6, paragraph 1, paragraph 16, paragraph 23, and 24. My lord, to save time, I'm not reading the facts, which is in paragraph 1. But, my lord, I'm reading paragraph 16. Here in paragraph 16. Here in my lord. Though Mr. Such and such senior counsel invited our attention to the judgment of this court in such and such and contended that the courts must not travel beyond the 4 corners of the order, which is alleged to have been flouted in the background, which we have explained above. We find it difficult to appreciate the submission. This court in the judgment referred to in paragraph 19 and clarified that the directions which are explicit in the judgment or are plainly self-evident can be taken into account for the purpose of consideration as to whether there has been any disobedience or willful violation of the same. Prima facie, we have reviewed that another single judge has taken not only of the plainly self-evident facts, well issuing the rule in order including securing the amounts which the respondents received by way of refund from the income tax department. Then, my lord, paragraph 23. Just to save time, I'm reading only 23, my lord. Mary, as held by this court in GTS Skipper Construction Limited, and going a step further, the court has a duty to issue appropriate directions for remedying or rectifying the things done in violation of the orders. In that regard, the court may even take restrictive measures at any stage of the proceedings. That is in contempt petitions. Then, my lord, 1996, 4 SEC 622.
These judgments are regarding that order of the land of single judge.
Yes. The issue is, my lord, the other day, when the matter was dated, the Mr. Honorable Court in the judge, certain questions were issued, whether the land of single judge should have issued the order when the division bench judgment, Mr. Whether the 5/12/22 order would have been issued or not, and also at this stage, what order would be issued? So in that context, Lordship, the skipper's judgment, the paragraph 23, it said at any stage, even of the restrictive measure, it will be issued. Now, my lord, in this case,
That was a case of fraud, perhaps. skipper.
My lord, skipper, yes. What has happened was that direction was issued to restrain the company from not to sell the flats. But what has happened is, in disobedience of that, he advertised it for selling.
That is expressing contempt.
Then, my lord, the paragraph 17. I only read one paragraph here. My lord, paragraph 17, the contender should not be allowed to enjoy or retain the fruits of their contempt. Only that I'm done. The principle that the contender would not to be permitted to enjoy or keep or keep the fruits of his contempt is well settled. This court has clearly held clearly that undergoing the punishment or contempt does not mean that court is not entitled to give appropriate direction for remedying and rectifying the things done in violation of its orders. The petitioner herein have given an undertaking to the Bombay court. They have acted in breach of it, and another single judge had held them guilty of contempt and imposed a sentence of 1 month imprisonment. In addition thereto, the learned single judge made appropriate correction to remedy the breach of the undertaking. It was contended before this court that the learned single judge was not justified in giving opposite direction in addition to punishing the condemned petitioners for contempt of court. This argument was rejected, holding the single judge was quite right in giving appropriate direction to close the breach. Then, my lord, to save time, I'm not reading the other paragraphs, just the principles. Now, my lord, that is a position.
Now, after the single judge's order,
After the single judge's order, page 64.
15,
After the
well-
single judge's order, page 64 is the compliance, the
Hmm.
first reconstitution of the committee.
then what is the development later on?
Thereafter, lordship, thereafter is the final report, which we have, is at page 97 to the affidavit in opposition, which we have been referring to. But prior to that, my lord, kindly allow me to my lord, page 88. In the affidavit of respondent number 2, lordship, which your lordship is referring now.
Hmm.
We have annexed the duties.
Page 80.
88. Daily duty, detail, roster duty, even wise duty requirement. Election duties, the appointment depends on the requirements and subject to approval of Election Commission of India. Remuneration given to them during such drafting as per norms. Emergency preemptive measures, false strength, natural calamities, disasters, outbreak of.
So whether this newly constituted committee has prepared any report on?
Yes, my lord, this is as per the, this is the affidavit of respondent number 2, the chairman of the committee. I am reading the report. My lord, the report is from page 97. I'll read it out. Before that, I want to show this document, which is part of his duties annexed by them. What kind of duties we are performing? Just to show that, my lord. Emergency preemptive measures, false strength, natural calamities, disasters, outbreak of epidemics in respective areas, law and order, full strength, as assigned by the district administration as and when required in concerned areas, location, ROB duties and VIP duties. VIP is 80% of the total strength, more frequent during winter seasons, in average of 45 days in a year. Census economic survey, not full strength, but within the requirements. Not annually, but in both to the post. Boundary pillar inspection in the energy, it is in Myanmar, my lord, as requisitioned by the paramilitary forces, involve the villages of border villages in frequency of twice or more in a year as per requirement, public function as per requirement, COVID as per requirement. So these are the duties. Now, lordship, may kindly allow me to refer to documents that page 15, paragraph 4 of the respondent number 2. Thereafter, I'll go to the report.
Page
15.
Yeah.
As regards, my lord, respectively as under.
Paragraph 4.
Four, kindly allow me to read.
Yes.
So, paragraph 4. In compliance with the direction by this honorable court, the respondent reconstituted the expert committee to examine and determine the payment and entitlement of financial benefits of VGs. B. The reconstituted committee held its first meeting on 9/5/2023 and second and final meeting on 13/3/2023. It will be mentioned here and that representative of MHA such and such had joined the first meeting virtually. He did not join the final meeting. And my lord, in the first meeting, the chairman was also absent. I'll show from the report. See, that as directed by the Honorable High Court, the reconstituted expert committee is examined the case of the petitioner by drawing a comparative study between the village cards and the home cards in the light of the observation as directed by such and such. Then lordship is comparative. Kindly allow me to skip this. I'll only read page 18, paragraph D, merit D. The reconstituted expert committee has also examined the service condition of village development force serving in the state of Manipur. As per the service condition of the VTA personnel are performing duties similar to that of police personnel. That is about Manipur. From the comparative statement of VG, this service home guard is clearly established the nature of appointment duties and responsibilities discharged by the VG and the home guard are totally different. The village guards also cannot be equated with VTF serving in the state of Manipur in as much as village guards are not performing similar to that of police personnel. F. Minority is important. In the first meeting of the reconstituted expert committee, the representatives of the MHA participated virtually and relied upon the letter dated 4/12/2021 addressed to the Chief Secretary, Government of Nagaland. It is mentioned herein that the letter dated such and such addressed to the Chief Secretary of the Government of Nagaland, the Ministry of Home Affairs has expressed difficulty to enhance funds for payment of financial benefits to VG in Nagaland, 11/14. Malord, this is the letter we have read. Can you allow me to skip? Malord, then G. Mary, as directed by the Honorable High Court, after detailed examination as regard payment entitlement of financial benefits of VGs, the reconstituted expert committee decided not to recommend the increase of VGs at honorarium of VGs at this juncture. According to the reconstituted expert committee recommended as under Malord, this is part of the report. I'm skipping, I'll read it out after in due course. Then H, Malord, the Honorable the tribunal respectfully stated that as directed by this honorable court, a reconstituted expert committee has examined in detail the matter relating to enhancement of honorarium and other allowances of the VGs. As stated after detailed examination, the reconstituted expert committee arrived at a decision not to recommend increase in honorarium at this juncture. It is further stated that the reconstituted expert committee has taken a decision after detailed examination of the subject matter in light of observation or direction given by such and such. That the tribunal humbly admits that there has been some delay in complying with the order passed by this court. However, delay as stated here and above is neither willful or intentional, and the tribunal tenders his unconditional apology. Then lordship may kindly come to the report is page 97. The final report.
Yes.
Merit.
Yes.
Well, kindly allow me to read the whole report because this is the big issue. In pursuance of the direction of the Honorable High Court, Kohima bench in order dated 5/12/2022 pass of petition such and such, the expert committee to examine and determine the present entitlement of the financial benefits of VGs in Nagaland was reconstituted with the following numbers and the terms of reference for consideration of the committee, which is reproduced below. Terms of reference, Malord, kindly allow me to skip this. I'm reading from paragraph 2 because this has been, it's only repetition. Merit from 2, Malord.
Yes.
On the basis of direction of the Honorable High Court, the expert committee to examine and determine the payment entitlement of financial benefits to VGs in Nagaland were reconstituted as stated here and after enclosed. G. The meeting of the expert committee was held on 19 May 2023 at NIC BT Conference Hall, where Mr. Such and Such Principal Secretary presided over the meeting since the chairman was on official tour outside the state where the proceeding will be seen in the minutes. 2. The final meeting was held on 13 June 2023, the Finance Department Conference Hall. 5. Discussion and decisions arrived at the two meetings were mentioned in the annex enclosed. However, a brief statement and the major topics discussed for attending to the demands of the beaches based on the direction of the Honorable High Court is reproduced below. A. On the comparison between the beaches in home cards as per the brief statements of comparison, the House agreed that since the work of the two organizations were quite different, we not be treated in equal terms of responsibilities, duties, functions, which are totally different. B. The representatives of the MHA mentioned that the village card, kindly allow me to appreciate this fact. It is recorded representative of the Minister of Home Affairs, not an expert committee member. Mentioned that VG is a volunteer force appointed on the recommendation of the village council to help law and order machinery in the rural areas and mostly to guard their own villages. Except when their services are required, the villages are free to carry out their normal cultivation practice and other activities in their respective villages. Whereas home guards are recruited after following due process and perform duties on regular basis and can be posted anywhere in the state. In these as such, VG's claim of parity with home guard does not appear to be justified. Further, MHA reimburses 90% of the expenditure borne by the state government for employment of VGs for security duties only, despite severe budget constraints. MHA has already doubled the remuneration paid to the VGs from 15 to 300,000 as per with VG with effect from 1/4/2018. As such, it will not be possible for MHA to enhance payment of initial benefits to VGs. However, if the government of Nagaland intends to increase their remuneration, it will do so from the state-owned fund. This is communicated via letter dated 4/12/2021, which we have been referring all along. C, madam. The House also deliberated on the issue of reference to para 39 of the judgment of the Infrastructural pertaining to duty allowance on a bar with 1 day wages of the police in the concept of living wage with reference to provision in Article 43 of the Constitution with Supreme Court in fixing such and such equal pay for equal work honorarium vis-a-vis minimum which is prevalent in Nagaland state. However, this is important. However, since the representatives of government and the government of India, Mr. Such and such, had clearly opined during the last meeting of the committee held on 19 May 2023 that the VGs are engaged only in rural areas as in winter services are required and duties are periodical in nature, whereas the home guards are an auxiliary force of the civil police and engaged in static duties in various institutions and also for traffic control, disaster management, and in maintaining law and order in the state and also utilizing terrain in the central district government function and retreat. The House was of opinion that enhancement of the honorarium as demanded by the VGs is not feasible at this stage. D. The representatives of the VG also put their own views and comments on behalf of the VGs Association where the grievances of the VGs were shared. Further stating the duties performed by the VGs in the international borders in the direction of the district authorities as when required. He also shared that though low honorarium wages without any facility as a discipline force to venture out to places where even the police and army are elected to move for duties, and also how the VGs take crucial role by participating in contingent during that latter days in also meeting with the military forces as when here invited for discussion on international border matters and law and order situations in the concerned areas and reiterated the demands before a committee for enhancement of duty allowance of village guard at such rate empower the police personnel which has been excluded from home guards. The House discussed at length the plea of the PG representative pertaining to the village defense force of Manipur. As such, service conditions obtained from Manipur, such and such, were discussed thoroughly in comparison to roles and functions of the BTF of Manipur without the BGs. It was observed that condition, rules, functions, therefore, between them are quite different. But not in Nagaland, it is called BG, in Manipur, it is called BTF, Village Defense Force. Here it is village guards. But they are paid 7,500 at the moment in Manipur. The recommendation of the expert committee reconsidered and also including the recommendation made by the previous expert committee for reconsideration of the committee is listed below. Recommendation of the expert committee, previous expert committee, Lordship has read. Then recommendation of the reconsidered expert committee, grants of rewards for heroic deeds and achievements to those VGs as acknowledgement which should be specific to law and order, duties assignment including expression. Chief Minister Health Insurance. This is entitled to everyone. As for the pay and allowances of the VTF in other states, and detailed discussion was held after applying the guidelines and the rules to be in function perks and allowances being paid to be given. Now, in report, after much deliberation, the House come to a conclusion that the role to be in function of VGF in Manipur and VGs in Nagaland are quite different and just limit the honorarium to the state VGs equivalent to that of Manipur. VGF in Manipur is not possible. The members of the committee were of the opinion that the basic demand of the VG Association remained mainly to enhancement of honorarium of the VGs, which is being paid by the Ministry of Home Affairs. The views and opinions of the members, including that of the representative of VG Association, and especially that of the Ministry of Home Affairs, Governor of India, which pays the honorarium to VGs, he stated to regret, which has been reproduced at length in the foregoing para. The committee reiterates the view of the earlier committee that increase of honorarium of the VGs at this juncture is not recommended. So, my lord, it is only a reiteration of the first committee report, and which is rejected by this honorable court order dated 5/12/2022, and the direction was given to reconsider. Because, my lord, finally, the last 2 lines, it is a reiteration. So, my lord,
That is, they have reached the same opinion.
yes, but my lord, the thing is, it is reiteration of the first, but lord.
So after submission of this affidavit in opposition, what is the court proceeding? What is the court proceeding?
Yes, 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 that is the issue.
I have to see.
Now, my lord.
This was in September 2023.
Yes.
Then what
Thereafter,
happened?
lord. Thereafter, my lord, I filed an affidavit in reply. My lord, I filed an affidavit in reply to the of the petitioner to an affidavit in opposition filed by respondent number 2, which was filed, my lord, in the month of September 2023.
Who are these respondent number 7, 8, 9, and 10?
My lord, you are expert committee members. 10 is the representative of the MHA, and the others are expert committee members. My lord, all of them has filed identical affidavit in opposition, so I'm relying on the affidavit of respondent number 2 will cover for 2 to 9. 4 to 9 not will be covered by squarely because it is identical. Now, may I read to a document which I have annexed. After submission of the report, Lordship,
Which one?
my affidavit in reply to the my lord, the commissioner is the ex-officio commandant general. He is the head of the department of VGs. On 7th of June 2023, my lord, he has submitted a proposal for enhancement of each VG's honorarium. In inviting a reference to the subject cited above, I am directed to forward a proposal for enhancement of VG's honorarium. This is for kind information, necessary action, please. Lordship, may kindly see there. Next page. Exercise on enhancement of VG honorarium 2023, VG personnel 29,508, minimum wages 5,218. Next one, 7,500. If BG honorarium is raised from 5 to 5,000 such and such at present, then additional requirement such and such. If it is raised to 7,500, then such and such. So in terms of minimum wages, this is a proposal submitted by the department to the government. My Lordship may kindly appreciate this fact.
But
That's a
this
hope-
is outside the thing.
Exactly.
We are into the judgment,
My Lord,
division judgment.
I understand. The point I'm just to highlight.
Court has no objection
My
if
Lord,
if
my Lord,
the
I'm only,
government acts on this proposal.
my Lord, the point I'm making is, the only point I'm making is, the commissioner is also a member of the expert committee. This is his proposal. And home commissioner is also a member of the expert committee to whom it is submitted. So even after report is submitted, this process is ongoing. I'm just trying to highlight, that's all, just for Lordship's concern. Now, my Lord,
Question is difficulty is that they are not, because we are not experts. Court cannot assume the position of experts.
yes,
Nowhere it is said that we assume the role of experts. A minimum wages, whether these village guards can be paid or not, because minimum wages is counted on a different basis.
I understand.
And they perform different duties. If they have come to an opinion that this is not comparable, we also find it difficult to express a different view. So far as there is discussion in the report,
Yes,
A, B, C. Though it has taken cognizance of that Ministry of Home Affairs letter, but might be influenced by it. Might be influenced by it, but they have recorded ultimately that we are of the view that.
My Lord, I'm coming with that. That is a very pertinent question you asked. Lordship, that is why, my Lord, I'm giving you the minutes from the first expert committee. How the decision making process, how the decision process was taken. My Lord, direction, as your Lordship has rightly pointed out in the first hour, is a classic case of putting the cart before the horse. That cannot be denied.
That is without going through all this.
Yes, yes, but then, my Lord, just an opinion, just an opinion. I'm not saying a ruling, it's an opinion expressed. Now what has happened? My Lord, committee was constituted. Just to recapitulate what has happened. The first committee was constituted. The representative of the MHA, my Lord, it is not the expert committee member. He considered him to be representative of the MHA, and all along he is acting and expressing as if he is representing the MHA in all the meeting minutes. So, my Lord, what has happened? First, MHA, what is the first report? He decided that, look, we cannot take a decision. So let us approach the MHA. And the home commissioner, now when the expert committee was having his deliberation, a parallel proceeding started. And the home commissioner, Nagaland government of Nagaland, wrote a letter to MHA, secretary, addressed to the secretary MHA. What to give your view, to give the approval. And the reply was, because of fund constraints, we cannot. That was the reply. So in the second expert committee meeting, that was produced, that look, this is a direction from the MHA, though MHA is not present, we cannot take any decision because this is the issue.
But that is not the sole issue.
My Lord, can you allow me to conclude this? Can you allow me to conclude on the issue?
Yes. This is.
Thereafter, my Lord, on that basis, my Lord, the first committee report was submitted, which was rejected by this honorable court. And Lordship may kindly appreciate this view. Now, the issue, the yardstick to determine is the order of this honorable court 5/12/2022.
Yes.
Because the expert committee was constituted on the direction of 5/12/2022 order. My Lord, Now, rightly or wrongly, they have accepted it. They did not file any modification appeal against 5/12/2022 order. So, my lord, the subsequent actions of the expert committee, the two decisions, the two meeting minutes in the report has to be examined in the light, my lord, of the judgment passed by this honorable court in in the contempt petition on 5/5/2022, my lord. And it says, lordship, if lordship, subject to repetition, if lordship allow me to read the operative paragraph over and over again. 5/12/2022 orders, because this is holding the field at the moment, and on the basis of this, the committee was reconstituted. And the report was also submitted on the basis of that only. Well, paragraph 8.
Yes.
Well, paragraph 6 also will be relevant. 6, 7, and 8. The submissions of my learned friend, where he had considered. Six, 8, and 9.
I'm reading paragraph 8 and 8 again, but still, this about that in any case, Presidio fund cannot be a region. Okay,
Yes.
that is okay. That is okay. For denying entitlement. No, what entitlement? Who will decide? Question is, we are not pay anomaly committee or this pay revision committee or like that. It is the committee of experts. Like we cannot sit over pay revision committee, pay anomaly committee, or all this step up committee, whatever. They are denying entitlement. Entitlement will be determined by whom?
The issue is this.
Because I find it very difficult.
Well, the issue is this. One.
Mr.
Hello?
Paragraph E. I have some.
My lord.
Yes, knowledge, they have shown recovery. They have got combination. We are of the considered view that this is quite meager.
Yes.
Right.
One of the issue is this.
The court has considered a committee. They have reached a view.
My lord, before I go to the merit of the expert committee, which is also the first issue is this. The second expert committee was constituted. My lord, on the first day, the chairman was absent. On the final day, the MHA representative of the MHA, the most crucial person was absent. So in the absence of the chairman on the first meeting, and my lord, on the second meeting, in the absence of the MHA, representative of the MHA, the expert committee has taken the decision. So, my lord, from day one, I am making a humble submission that at no point of time, since the very constitution of the committee, the first committee also, my lord, the representative of the expert committee from the MHA never participated even once. But the party took a decision Then in the second committee, expert committee meeting, the chairman from the report was absent on the first day, first meeting, and the representative of the MHA was absent on the second day. In the first meeting, my lord, the MHA representative of the MHA had participated from Delhi.
But
There is not even one.
right, but there is no question regarding quorum.
My lord, quorum was never decided
Write
here.
down quorum.
My lord,
But ultimately in page 101, everybody signed.
my lord, no, not everyone signed.
Come to page 101. Yes, not signed by the Village Guard Association.
My lord,
Definitely now, yes,
my lord, not all. Lordship may kindly see.
your representatives
My representative did not sign. The
and
government
Commissioner Secretary.
Senior did not sign. Lordship. Not all members signed.
If somebody does not sign, how? can
What
it
the
be?
issue is, my lord, yes, I understand. But my only concern is from day one till date, he did not have a serious deliberation even once, not even once. All the members physically had a meeting, took a decision on the issue in a very, because the issue was to delay. From day one, they had a predetermined mind that you're not going to consider. So, my lord, this is one aspect of the matter. My lord, I leave it to your lordship on this issue, but when there's not even one effective, serious consideration, whether we can see that expert committee has properly considered. That is one of the matter I'm disturbed. Because, my lord, if this even once, because the chairman was absent, the expert committee member was, the MHA was absent, and lordship.
Now,
Lordship kindly appreciate
no,
this.
I am quite alive to the
And-
grievances of the Village Guard Association. Now, in view of such
lord,
submission of committee,
Yes,
I am putting across to you.
yes,
I am putting across to you that whether this report,
yes.
since there is no signature of the Village Guard Association.
Fine.
That is what, please bear with me. I am
Yes,
alive to your grievance.
yes.
That whatever be the report of the committee,
Yes.
report of the committee could be by majority also.
Fine.
In that case, the minority view is also to be recorded in the
Yes,
report,
yes.
like the president and general secretary of the Village Guard Association. The committee reiterates without signature. Mr. Jamid, it is for you also. Please come to 101.
I have one.
There may be
Dissenting.
9 committees, 9 members, suppose. 5 will comprise the majority. 4 will be having their own views,
Dissent.
and ultimately, like the parliament or whatever, majority view is this, and dissenting view is this, or minority view is this. They should be recorded, and there all the signatures should be there, as if this report,
Yes.
whatever be the opinion, then thereafter it will be taken forward. But question is that here the village members, guards associations, their thing is recorded in paragraph D and paragraph E. Right. And no signature was obtained without the absence of the signature. But recording their views, there should have been signature that we have dissented.
Lordship, kindly allow me to in my affidavit in reply, paragraph 4,
Yes, please tell me.
I read. Accordingly, the president and secretary appeared before the village guard association, appeared before the secretary of the expert committee on 4/7/2023, and he refused to sign on the ground the report is in clear contravention of the judgment in order that is such and such. It is also stated that in the earlier expert committee report, which was rejected by the Honorable Court on 5/12/2022, the President had refused to sign the report and also submitted a representation that a dissenting opinion be recorded in the report on his behalf. As such, the standard respondent number 2 that so, my lord.
Yes,
from-
what is the reply in the affidavit? Is there any reply to that?
Reply to them is, in fact, it is clear, they themselves, they refuse to sign. So far as signature is concerned, your lordship, if they refuse, we can't force them, but dissenting view.
Yes.
Lordship, yes, that ought to have been, that I concede your lordship. That dissenting
Because
view-
dissenting minority view is this, these are the things, it should have been recorded.
But signature can't force them to sign.
Can't force, but at least.
The issue is this, from day one, my
And
lord.
there should be, it should be recorded also that they refuse to sign
Yes.
in the report.
In the report.
No.
In the report.
No, your lordship, after the report was prepared, it was given, so in the report, that could not be signed because report was ready only but for signature.
Then there should be a
Attender.
note below,
Yeah, no, so my lord, the issue. is-
NB, that this,
My lord, that's why on the first report also. We submitted in the second report also, all along we have submitted representation that we disagree, so include a dissenting opinion, because lordship. Kindly appreciate this fact that if the report is submitted along with the dissenting opinion to the state government and government of
Yes.
India, who knows?
yes.
The committee, the higher authority would have extended my dissenting opinion.
In many judgments, dissenting view has become later on precedent.
Yes, so that opportunity is not given, and if a dissenting opinion is enclosed, my lord, then definitely the government of India or the government of state government could have called us for negotiation also, my lord. That
Yes.
opportunity is denied to us. Not the whole door is shut. So, my lord,
That could have been added, dissenting view. That was.
my lord, I appreciate the fact that this honorable court has limited power to review an expert committee. That I concede, no issue. That is why, my lord.
That is why I am trying to
That
find.
is why.
I am
my lord,
alive to
that is why
situation.
I'm not.
Mr. Life.
That is
8,000.
9,500. Yes. And lordship, 3,000 in a month. And
I am alive.
that,
But I am also alive to the contours of content.
My lord, yes.
I am also alive to the situation of this court sitting over committee of experts.
My lord, that is why.
Being alive to the situation,
My lord,
I am
that-
trying to.
That I appreciate, I highly appreciate from day. My lord, I
I have some reservation about this order. But since it is not appeal,
yes.
so it is holding the ground.
And the notification also was issued, reconsidered in compliance with the order of the single bench, and report also was submitted in compliance with the order of the single bench in the contempt. My lord, that is a subject to repetition. My lord, I am not trying to find on the findings merit given because there is a purview of the expert committee, I concede. But the only thing I am trying to project to your lordship is one. My lord, no effect, not even one effective hearing has been done so far. That is one sufficient. Secondly, lordship, the expert committee. One of the issue is this, whether the committee has considered the issue as a member of the expert committee or as representatives of the government of India and the representatives of the state government. That is the issue, lordship. My respectful submission, at no point of time, he had considered and examined the matter independently as a member of the expert committee. He have been only representing the government of India as well as the state governments. Because the noting says representatives of MHA. It does not say, my lord, expert committee member, represent from the central government. All along the order says representatives of MHA. And by functioning and second, my lord,
There in the constitution of the committee notification itself, a representative of the MHA.
my lord, that is the issue. That is the issue. A representative
It has
of the
not been,
MHA, fine. But whether, my lord, he had represented on his personal capacity expressing his expert view, or he has only conveyed the wishes and opinion of the government of India, that is the issue.
No. Your president and general secretary were also there.
Yes,
Right. Now, here, president secretary may also change,
yes,
right? Then it is ex officio
yes,
for president and
Yes,
general secretary,
yes.
not by person.
no,
And this a representative of the MHA.
yes,
So today X may come, Y may come,
fine, I have no objection to that.
or
Anybody
may not come also.
Anybody come,
Quorum is also not there.
anybody may come.
Hmm.
But the issue is, my lord, whether he had expressed their expert view or only conveyed the opinion of the government of India. Because all along, the representative,
No, that will be Mr. Takamasa, that will be a case of cause of action for filing a
my lord,
petition.
I am coming to that.
I am quite sure about
I
that.
am coming to that. My lord, the issue is this. So, my lord, this,
Rightly or wrongly, they have to reach an opinion about examination and
Lordship,
determination.
Lordship may kindly see the paragraph 29. I am going back to paragraph 29 once. Because ultimately it is this,
29.
yes. In that view of the matter, we direct the state government to constitute an expert committee to examine and determine the payment entitlement of initial payments of wages in consultation with MHA. The expert committee includes such and such, my lord, I'm skipping list. Well, next page, while considering the matter of enhancement of honorarium and other allowances as directed herein, the committee shall take into consideration the observation and direction given by the apex court in such and such.
Whether, whether in any paragraph prior to 29,
Yes,
whether the division bench has expressed an opinion or observation that they are entitled to any enhancement.
my lord,
See, then it will be content.
my lord,
From paragraph 1 to paragraph 28, whether
Yes.
there is any statement of the observation of the division bench that they are entitled to enhancement in the honorarium.
my lord,
Because question is,
my lord,
though not, I am an expert in lyrics, but while considering the matter of enhancement of honorarium, while considering that bears two things, two meanings.
not while-
If there is any express observation already by the division bench that they are entitled for enhancement in honorarium, then it will be contempt, that the contempt committee reaching a view. Am I clear? It is a fact that commissioner is also outside the jurisdiction of the expert committee. He is saying that they should be enhanced.
my lord, to be fair, the learner single judge, the revision bench, you said that can be determined by a panel of experts. Fine. Now, note but last paragraph, last 3 lines of 29. The recommendation made by the committee shall then be forwarded to the state government in the home department and also to the Ministry of Home Affairs, Northeast Division for approval and further necessary action.
Whether forwarded,
My lord,
committee has forwarded or not?
my lord, in my respectful submission. The committee has only reiterated the first report, subject to repetition. Now, when the first committee report was rejected by this honorable court, that the learned single judge, that the expert committee has failed to appreciate the judgment and for reconsideration. So, my lord, when an earlier report has been rejected, whether it is proper for the second expert committee to reiterate the first report, which is already rejected by this and found to be is rejected. That is the issue, Lord.
Yes, formulating that statement is not correct. Because by the order dated 5/12/2022, it appears that the earlier committee report
Yes.
has been wiped out of existence.
Yes.
Say,
Yes.
prima facie.
So, my lord, when that is wiped out, whether the
Prima facie,
Yes.
I'm saying
My
prima
lord,
facie.
I'm submitting. I agree.
It is not expressly
No,
said,
I
but
agree, because it is only an opinion expressed. So, prima facie, when the first opinion has been wiped out, that means when the first report has been made, void of an issue, whether the second expert committee had any legal right to reiterate the first committee report, which is no more in existence. If they give a different, separate opinion, not reiterating the first committee report, then issue will be different. Lordship, you can appreciate that.
but whether that has been set aside expressly.
Which one?
First committee report.
Well, Lordship, you can see the last paragraph.
See, legal terms are very difficult.
Why not? When the first, why not? I'm reading, my lord. It appears that the directions given in the writ petition and the writ appeal have not been done into intent to understand the same and their implications. Further, from the step taken so far as it is seen from the meeting minutes, it appears that there is lack of concern in wholeheartedness in dealing with the issue. The appellate court directed in constitution of the committee so that the issues involved and the implications thereof are deliberated thoroughly, so that the grievance of the village clerk whose service has been acknowledged and uploaded may be included such and such. Then, my lord, in any case, paucity of harm cannot be such and such. Then, my lord, paragraph 8(9). From the report, it appears that the state respondents have taken some steps. Therefore, this court is of the view that we have not deliberately ignored or neglected compliance with direction. Therefore, my lord, this is the issue. Therefore, the respondent number 1 is once again directed to reconstitute the committee in the light of the submissions made by Mr. T.B. Jamir and the other counsel representing the other parties within a period of 1 month from today. Because, my lord, in paragraph 6, they have admitted the fact that he tried to comply with the direction, but fallen short of full compliance. My lord, paragraph 6. Mr. Jamir, my lord, where it is? Paragraph 6, my lord. Page 11.
Yes.
Mr. Jamir further submitted that the respondent number 3 and the other respondents, at least in their part, have tried to comply with the direction given in the writ petition and the writ appeal, but have fallen short of full compliance because of the view expressed by the Ministry of Home Affairs. Therefore, feel should be given another chance. And in that view of the matter, when they themselves are conceding that they have not complied, my lord, further direction was given to comply.
Where is annexer 4 to this report?
Well, there is a next by this one. In your complaint in the afternoon.
Hmm.
Worship, I reproduced the same at page 16, affidavit of opposition. Worship, that's what it is. Page 16, your worship.
That is extracted from annexer 4.
Yes.
Annexer 12, Roman 12.
The statement,
Annexer Roman 12.
statement and comparison.
Page, annexer Roman 12.
Page 82. And actual Roman law. There's a detail. Compared with.
All of the issues is. Now let us single judge, the division bench direction. One of prior, it only says, examine, right? Then secondly, crowd objection. Well examining, consider crowd objection. These comparative statements are included. Now, my lord, the issue is this. The Learner Division Bench have discussed about equal pay, equal work, and all this in the preceding paragraphs. But in the operative paragraph, he come to a conclusion and say, because lordship, para 29, a paragraph 39 of crowd objection.
Yes.
Is, my lord, it is not the pay enhance, the revision of honorarium for the home guards was not on the basis of equal pay for equal work.
This cannot be because the duties are different.
My lord, because lordship may kindly see the paragraph 39 of the judgment, division bench, it says, consider, well consider determining, well consider.
That is not applicable on all fours. You take note of that.
Yes.
It is not applicable directly. You take note of this reduction.
Yes.
I am trying to, because
that is why my
court is also helpless because there is nothing like equal duties and responsibilities.
The issue is this.
And this annexer, Roman 12, to the affidavit of opposition, it is the Home Department, they have made a comparison. We cannot sit over there.
The issue is this. The comparison is made, I'm not disputing.
So Takamasa, actually, from very beginning, I am alive to the grievances.
No, I'm only on that comparative example. I'm not coming on the other issue. My lord, I'm not on the other issue, on the comparative of the Home Department after two. My lord, the issue is this. Whether it is necessary to make any comparison by the committee in the first place. Because Lordship, we can appreciate this. Because Grad Raksha judgment only says that give it to the home guard, give the skill of a policeman to the home guards because while performing their duty, when go for duty, they are performing the duty of a policeman. That is the only issue. So, my lord, in the present case also, my lord, for the expert committee and for that matter for the Home Department, we have not considered that crucial aspect, whether when we are called for duty, whether we are performing the duty of a policeman. But from the comparative statements, my lord, it is crystal clear that we are performing the duty of a policeman, if not more.
Come to page 82, annexure Roman 12.
Yes. My lord,
Uh,
my lord.
these are the comparison made by the
My lord.
Home Department.
Lordship mechanism 3.
Now come to paragraph 28 of the division bench.
My lord, kindly allow me to read paragraph 3 of the comparison. The role of the police, village guards, are primarily to assist the police in curbing criminal activities, route opening party, international border patrolling, providing help to the security forces in the counter-insurgency operations, and in the form of guides, round-the-clock security in the respective villages, involving in barracks during later tea like such and such, providing assistance to village sheriffs during natural calamities in offering any help, and guide us in when your services are called for. Kindly read, allow me to read the right side. The home guards are an auxiliary to the security police. They are posted for static duties to provide security in the various institution pipelines, BRD quarters, specific areas in vital institutions, traffic control, disaster management, etc. in maintaining law and order in the state. They are also designated as civil defense force in the state. Their services are also utilized during the Miscellaneous and state operations. They are also posted for security in the town forces, sub-treasuries in the subdivisions, and in almost in the directorate offices in the state. My lord.
Come to paragraph 28 of the division bench judgment.
Yes, I am alive to that.
6th line. Besides the honors.
Yes. Paragraph 28, Lordship, yes.
Besides the honors of established. Says 8th line from bottom. Paragraph 28.
Page 44 or 45, Lordship?
No, in the judgment, division bench judgment, paragraph 28.
Yes.
Above paragraph 29.
Yes.
Say 9 lines from top below. Paragraph 28, come to the end. Come to the end of paragraph 28.
Yes, therefore, to claim parity of pay.
Besides, yes.
And the principle equal B and equal for.
Besides the honors of establishing the similarity of the duties and responsibility performed by the two sets of employees under competition, same has to be determined by a panel of experts who possess the expertise and metrics for explaining them the claim for parity of pay. Therefore, it would be only appropriate if the exercise of finding out the similarity of duties and responsible duties performed with the PGs can be carried out by the panel of experts. As already noticed, the applicants are also agreeable to the fact that the matter needs to be examined by an expert committee. So,
then, Lordship,
actually, I am trying to find out something which is through which, because we are not sitting in a writ petition, we are not adjudicating in a writ petition. That is the difficulty I am finding.
But the issue is this, the issue is, we are, of course, going over and over again.
Right, but I am also going over and over, still trying to find out. And first, I have to be convinced with myself.
My lord, yes. So, my lord, the issue is this, subject to repetition.
Subject to whatever Mr. Takamasa in the case would see another light of another day, perhaps. Because I'm trying still not finding a way of navigating out of this situation. Division bench judgment, single bench judgment order 5/12/2022, and this expert committee report.
Yes.
And to out of them to find a way out of the still limiting myself with the contours of contempt jurisdiction.
Yes.
I'm basically.
Because Lordship may kindly see.
I should be fair to you, but
my lord, I have read the judge, and my lord, I will again rely on the paragraph 23 of the scheme of the judgment,
Which one?
which, my lord,
Half compliance, full
2007.
compliance.
yes.
Half
No,
compliance.
2005 SCC, that is scheme of observation. Paragraph 2017 5 SCC 506. 2017. That is why, my lord, I was trying to find the, I kindly allow me to read the two paragraphs again. 2017 5 SCC 506. This Mazdor Sang versus Bharat Jute Factory, my lord. My lord, paragraph 23.
Yes, paragraph 23, paragraph 1, 16, 23, and 24.
Yes. My lord, because my lord, if lordship may kindly see a paragraph 23. And it was.
Because otherwise also, because I'm still trying to reconcile everything, that in contempt jurisdiction, the court does not have the jurisdiction to authority and jurisdiction to completely set aside an order.
No,
That cannot be. Yes, can appropriate direction.
my lord,
So,
what I am approaching before this honorable court at this juncture. What I am approaching before this honorable court at this juncture is, my lord, to give a direction to, in the light of the fact that, my lord, the fact that there was no dissenting opinion, no opportunity given, our right has been deprived, that is one issue. Then under dictation from the central government, letter, there's been issued at no point in time and effective, any
the
effective. thing has
second
been done.
submission will be second submission, Mr. Takamasa, it is a cause for repetition.
My lord, I'll come to that. Because, my lord, the issue is this.
If the
My lord,
expert committee appears to have been guided, that is a matter of interpretation.
the issue is this. In a similar case, my lord, time is going to be 4 o'clock. So I will be relying on another judgment, last judgment, which says, my lord, whether the expert committee report issues that have been said, whether it will be a fresh cause of action to file a writ petition on that. That I'll be coming to that point. Since we're,
Yes, yes.
I'll be coming to that point.
I'm learning also. I'm learning also.
That will be, because, my lord, in a particular case, what has happened in that particular case, my lord.
But definitely they are entitled to challenge this expert committee. There is no bar at all. I don't think it is bar.
In that particular, what has happened in that particular case was, my lord, the police constables in UP, he appeared in an interview. And you were selected as constables. And your appointment as constables were set aside, were cancelled by the government. So he approached the honorable court, High Court. The High Court gave a direction for reinstatement. Then a contempt petition was filed. That he should be, upon reinstate, they are entitled for paid wages from the date of their initial appointments. That has not been given, we are reinstated, but we have not been given our paid wages from the date of initial appointment, so it is contempt. When it was filed, the London single judge, as well as the division bench, had rejected the plea on the ground of payment and entitlement of paid wages is a fresh course of action. That they should approach the appropriate court by filing writ petition. Now, appeals were made before the Honorable Supreme Court also on the issue. Initially, when the first order was passed and the appeal was filed against the single bench order before the step export, certain interim order was passed. Thereafter, taking the plea that fresh cause, it's a fresh cause of action. And if at all the parties are agreed to file a writ petition challenging the non-payment of the paid wages. Now, the Honorable Supreme Court held that there should be a quietus to all litigation. And the Honorable Supreme Court, and which was considered by both the parties, accordingly, the Honorable Supreme Court, my lord, from the date of filing of the writ petition, my lord, in the appellate stage, the Honorable Supreme Court, from the date of filing of the writ petition, have given them paid wages, that is, appeal against the complaint structure, and lordship, cost, litigation cost also was given. So the issue is, I'll be, because
That might be under Article 142,
my lord, the issue is
which we do not have.
what the principle. Because the principle involved.
Oh, but Supreme Court has been rated, don't exercise 142 power. High Court, don't exercise
But-
142. We will exercise only.
The issue is that is, I have no comments
Right.
there. But the issue is,
I am asked.
the point I'm
I'm
urging,
trying-
lordship,
I'm trying to gather from your submission to way out to
my lord,
giving.
it is,
I'm trying to find out the way out, give out of this.
my lord, it is 4 o'clock. Can we keep it part head and continue Monday so that I will,
But no, I'll be sitting in division. bench.
then on Thursday, because by 9, in any case, we can't conclude it today.
Thursday will be again, you were there or part division bench? Virus. Thursday, we have fixed the part division bench. Yes, somewhere there.
Police department, education department. Education and family.
Yes, virus of rule.
Well, since it is going to be part head, we can conclude that day because in any case, 15 minutes,
No, I'm still trying to find out that. something-
my lord, I'll try my best to satisfy by, my lord, compiling all the submissions together in the gist.
Another thing, another urgency is there that yesterday's order is to be signed.
Or it will be on Friday, lordship, or part head on Friday, we can, because it wouldn't take much time on Friday.
We can make a chance on Thursday, but if not possible, then it will be released. If the division bench takes up the time. Because
Because, my lord, I'll take another,
Kohima, I have come to stay here from Gujarat. My son was admitted in the hospital for 7 days. Then I have taken him back. See. 7 days. That's been serious. I was on leave. I was not sitting in the critical bed. Later, after 1 day, it was I see. I was on leave for more than. So that taking. I knew you, but he is in, he was admitted in a hospital in Ahmedabad. He was almost on the verge of sending into the ICU. But somehow recovered.
oh, I see.
He is in the recovery process. So Friday, I am not taking chance.
Then, my lord,
I'll take chance on Thursday.
because, my lord, from.
I'll try to give effort, but
My lord,
I'm not sure.
from my end, I'll take 20 minutes.
But
So keep it part head, lordship.
it will be listed before me. It is not by Sema, Justice Sema.
No, but since if it is kept part head, then the matter will be listed first.
No, I'll be taking your case. Since we are all two are sitting, so it will be listed before me invariably, and we'll take up your case at first.
My humble request, it will be released on part head if it is possible on Thursday, so to be safer.
At least the case, Mr. Learned Senior, Mr. Takamasal and his senior counsel has advanced in his submission, but as his submissions are not complete, release the case again
Yes.
on Thursday.
Yes.
Try to, I am
Well, let it be as
again,
part,
again,
let it be as part heard.
okay, Pathak.
Yes.
Thereafter again, puja vacation is coming. Hmm? No, I will be running back immediately on Saturday to Gujarat
Lordship, your son is studying which course?
in
Okay.
5 years,
Okay.
National Law University, Gandhinagar, Gujarat.
Okay.
Just first semester.
I see.
Hardly 20 days he was there, but more than 150 students got infected with dengue, then this thing, viral fever plus this thing. One more serious thing. Malaria kind of thing. Hmm?
Municipalities.
Not encephalitis. Another is viral fever. The third one is more than 150 students in a month. All three students, all the three in the room. All. One is from Maharashtra, the other is from Delhi, and third one is mine. All were taken back by parents, got admitted in hospital.
Oh. But now recovered.
Now recovered, all have recovered. But still very weak situation. Anyway, Thursday.
Lordship.
We'll take a chance. But I am trying to find out a way out of within the
Lordship, yes.
contours of contempt jurisdiction.
Lordship.
Had it been writ petition, I could have traveled anywhere. Huh?
Lordship is very research.
Yes. Had it been writ petition, I could have traveled. Everybody could have traveled. There is no limit. But contempt, it is bit limited. And we'll see. Any way out?
Yes. Because
we are alive to the situation of
our only humble prayer is to give a chance to the committee to re-examine once. That much.
That is what I am trying to find out, whether this court is alive to the situation that 3,000 is too meager.
Yes. And when they are Ashok Chakra winners and sacrificing their life in insurgency duties, they are every day, my lord, they are on the forefront.
Mr. Jamir, I am putting you a proposition. This home commission was a member in the committee.
Yes.
And when he expresses his opinion regarding enhancement.
After submission of the report.
Representation from the petitioner and petition is every time from new.
It is prior to the expert committee vote, whether he expresses his opinion. Kind of.
Yes.
Then if he has expressed his opinion regarding enhancement, how can he express a different opinion?
Exactly.
In a meeting.
It was.
In a meeting of the experts.
My lord, I think it was prior to the report. Prior to the report.
Then his stand is not.
Prior to the.
His stand will not be. Find out. Otherwise, his stand will not be bona fide. He has to express his independent opinion, right? Committee is not, since the other members are expressing opinion, he cannot go by their opinion. If he is expressing an opinion for enhancement of remuneration at an earlier point of time.
My lord, it was report was on 7th June.
And he has expressed his opinion regarding enhancement. Find out. We'll try to find out something.
No representative from MHA could not attend the session. So there was no effectivity. So because on that point, okay, I would participate, yes. There was.
No, that was the first report. What about the second report now?
The second, because of this pandemic, only once you get that. Through VC. So personally.
Mr. TB Jamir, learned counsel for the respondent number 2, and Mr. I Im Chong, learned additional advocate general for Nagaland for the 4 and 9. LT Sangtam, learned advocate, additional advocate general, Nagaland for 7 and 8. Yangarwati. Respondent number 1, 10.
Mr. Lordship, I am for respondent number 1.
Did you file any affidavit?
No.
Huh? Okay. Anybody else? Miss Anangami, respondent number 1 are present.
Lordship, I'm highly obliged for very patient. Because it's a matter of life in text for this 9,500.
No, that is right. Yes. Huh? Twenty. Anybody is present? Yes, anything? Madam?
Your Lordship, state respondent, are you to file affidavit?
Oh, you have waited for this hour? Yes, who is the state respondent? Mr. Angami? MSAIME. Okay, MS so learned counsel for a petition is present. Miss N. Angami, learned counsel, state counsel representing MSAIME. Learned government advocate has sought for and is granted 3 weeks time to file counter affidavit on behalf of the state response. This is the case after 3 weeks.